I may be pardoned to mention, my lord. This is for the press admission matter. Matter was last listed on 15th. I have already filed the consolidated writ petition where my prayer is specific. I have cross-checked the file and it has been filed. But in the registry they have done, in the main writ petition, they have added my consolidated writ petition's prayer. So let it be on, say, 22nd, my lord. Stay is required because contempt petition has filed and...
Well, it's here in custody, my lord. Never rejected you last.
Regarding upgradation of service in the High Court registry, it was in the list for several weeks, now delisted.
Final disposal, my
Hello?
final disposal.
My lord.
Cannot come.
Let it come.
Say, IF for failed, my lord, CRLA 401.
For interim value, that's it. Oh, bless you, that's it.
Interim bill interim bill
Yes.
My lord, your lordship.
Criminal affair gets been fixed for a 19 for a constitutional bail application. It is an issue. It is an issue. A constitutional bail application, they will give.
My lord, previous month, your lordship fixed a date this week. It has not been listed, so kindly.
When it was fixed?
Previous month.
Finally, it will come next week. Don't file memo. This week there are some problem. It will come automatically next. Don't file memo. The matters which you have placed for this week for final disposal will come next week.
No, it is not final disposal. It was admission hearing. After
Admission
yes.
is in which the opposite party has appeared. Hearings are complete, so that is to be taken for final disposal.
Your lordship, it will come on Monday or Wednesday.
I cannot say. It will come next week. That has been specific. On which date I cannot say now.
Pardon, my lord. Item 8, my lord. Item 8, I am appearing on behalf of Mr. S.B. Jana, my lord, for the petitioners. Let the matter be taken up after vacation, my lord.
Any interim order passed?
No,
You are not aware?
no, my lord. On behalf of Mr. S.B.
WPC 2174. No. All right. What is your good name?
Swayam Prabhu Jana.
Wait. No. Mr. So-and-so. Sahoo Jana, 6 for an adjournment. After vacation. Previous month. Yes.
May mention this is a fresh content application. The order is passed by this honorable bench in May.
Pardon to mention, my lord. I'm on VC, my lord. Item number 19, your lordship. The matter has been today. It is for some defect removal, my lord. My lord, a certified e-certified copy has already been filed as per your lordship's direction in previous order, your lordship. And there is some kind of delay is there, but the matter is not filed within the delay. It has been filed within the time, your lordship, because the writ petition was dismissed on 29/4/2020 and the review was filed on 15/5/2020, your lordship. Lordship, I just need some more time.
Review petition number is 219 of 2020.
Yes, your lordship.
The defect has been pointed out was 1669 days.
No, your lordship, that was not actually the correct thing. The writ was dismissed on 29/4/2020, your lordship.
Last order is pointed out. Last order.
And your lordship, we have...
1 minute, there is a report. 6 months.
Your Lordship, other minor mistakes
Please,
were
madam,
there.
please wait, have patience.
Yes, Your Lordship.
The stamp reporter has given a report, we are going through it and you are making.
Yes, yes. Pardon.
You was
Apologize.
but certificate copy was valid.
That is,
From certificate copy they have counted.
obviously, that will be High Court rules actually.
That is how it 1669.
So you didn't file the certified copy and the date when you filed the certified copy, that was taken as the valid filing and that is how it has been, in terms of the High Court rules, it has been calculated to be 1669 days. So you are to file an application for condonation of delay and explain it that this is the circumstances, whatever it may be, so to condone the delay.
You file a formal application.
Formal application you
Okay.
Your Lordship, actually, as per my instruction, Your Lordship, the writ was filed. The writ of the dismissal was done on 24th.
Madam, you have filed the writ. You have filed the review petition in time, no problem. But
Yes, Your
you
Lordship.
filed the certificate copy lately. So
Your
from the certificate date of certificate copy, the delay is
Right.
counted. Okay.
Yes,
That
Your
was-
Lordship.
okay.
I understand. I will file the same, Your Lordship, within 2 weeks.
Okay.
Much obliged.
Here is this is item number 19. Here is the report of the stamp reporter, wherein it has been pointed out that how the delay of 1669 days has been shown while doing the SR. The learned counsel for the petitioner appearing through virtual mode submits that he intends to file an application for condonation of delay, and the matter will be taken up after 1 week for put of this matter after mentioning the holidays.
Supplementary list
item. IA number so on so, which is an application for dispensing with filing of the certified copy. Since certified copy of the impugned order has been filed, the IA has become infructuous and accordingly distributed. Madam, you are also to pay the deficit court fee of rupees 225.
Yes, Your Lordship. I will do it in the course of the day, Your Lordship.
Also submit that so will also remove the other defects as pointed out by the stamp report. Yes.
Much obliged.
supplementary list item number 1.
Sir, item 1, my lord. This is the matter regarding the remanded back of the Honorable Court. Whereas the S civil appeal number 751/25. Flag X, yes, that will be referred to a larger bench.
Pardon, this similar identical matter has been referred to the larger bench.
Yes.
When Honorable Justice S.S. Mishra is a party, and the matter has been argued 31st October.
Oh, 31st October, number ta dwa data hai.
Last order,
Appeal number 2491/20.
last order, no.
Last order ଅଛି 21/7/2025. Yes, ma'am.
The learned
And
counsel
black
for the state
Black.
as well as the learned counsel for the petitioners in the writ petitions submits that this matter is connected to writ appeal number 2491 of 2023, which has been referred to the larger bench, and the larger bench is in session over the matter, and it was taken up on 12/9/2025, and the matter has been adjourned to 31st October 2025. The copy of the order dated 12/9/2025 passed in the appropriate appeal to file, which is taken on record. In view of such submission, these petitions be listed with writ appeal number 2491 of 2023.
Item number 2. India has filed this writ application challenging the order of the tribunal matter. In this case, what happened? 5 original applications were filed by different applicants before the tribunal, challenging the order of recovery as well as prayer for refund of the amount. 4 writ applications were dismissed by this honorable court. So, this is the same order. Same. I am corrected also. This honorable president needs to dismiss, directing the order part by the tribunal.
This is the 5th one.
This is
4th one.
This is the 5th one.
Why are you filing repeatedly? Once we filed.
Already 2023 madam. 23 October
Correction करनाहांती एक
गोटे correction
it is something confusing of without correction.
How achi pending?
Nine. That
This
display.
is the last one.
This was the point of the life.
Item number 3. Due to non-removable defect 2023 pending.
May I please mail order? Hello, here in this case, the order of the ombudsman is challenged. That is at annexure. We dispose of some matters.
Annexure 4.
We dispose of some matters, carry those judgments.
That case in non-case.
No. Last week we decided the case. Okay.
No, here Miller, the ombudsman has observed this case reference.
Ombudsman is relied upon this judgment. He is not.
This Kesininan case has been referred by the ombudsman, which was cited by the other side before the ombudsman. And then this said case is quite different, Miller. This is the transfer with regard to transfer of a property. The person who
We
has
are appealing for the opposite party number 1.
and so far the transfer is concerned, and a transferor and a transferee, Miller, if there is charges, electricity dues are outstanding in the premises, then person who has purchased the same,
Facts are, if we are not confused, you are the original owner, of course.
yes, no.
You had rented out to someone else.
I
And the
have
due
permitted
to be paid by the leaseholder, he is not paid. Now you want the electricity
No,
connection,
they are saying that-
they are saying that you have to
Yes.
pay the entire.
Miller, it is two things here, Lordship may see.
Said no.
Here there is no area.
Which
Here
matter
there
we
is,
have decided.
We have
finally?
decided on one matter.
8 Prajamkul 9 he is liable to pay.
Perhaps with the other discount because
This might say matter.
Decided that the original owner is entitled, have to pay.
He has
Yes.
to pay. That is
He
the
has no
order.
in terms of case,
Yes.
Find out.
here.
I know that.
Here, my first submission is.
We
there
can't
is-
take a contrary view, even if you
I am
hear.
not saying that, Miller. I am bound
We have
to.
already, you go through the decision.
You
We have
see that
decided.
we have passed an order.
Here, Miller, there is no area. Rather, the Disnet Wireless Company, Miller,
Yes, next.
he has to get more than 50,000 from the department. Item 4.
The Learning Council for the opposite party number 1 submits that he has instruction that in identical matters, some orders have been passed by the court. The matter may be taken up next week so that he'll find out.
I'll find out in the meantime.
Yes, next.
Item 4.
Are you appearing in person?
No, I'm
Where is your band?
sorry, my lord.
Go. immediately.
Where the band?
My
You might have forgotten.
Yes. Tortorica. The lift.
I'm here, Narasimhan, proceed. I am here.
Yes, Mr. Pari.
Yes, I'm sorry already. Yes. Narasimhan, proceed. I'm here.
5. Next matter, Dr. Paso.
Item 5.
The password.
The order dated 6/5/2025 passed by the Central Administrative Tribunal Cuttack Bench, wherein
my application for review or rejected on the ground of delay. The fact remains that, my lord, the petitioner joined on duty on 8890 as casual vehicle driver. And subsequently, after completion of 180 days, the continuous service, he was accorded the scale of pay of rupees 950 to 1500 rupees, with effect from 8 to 1991. Thereafter, on completion 360 days, in continuous service was granted temporary status with effect from 7/8/1991 as a driver grade 3. Thereafter, he was promoted to MB driver grade 3. Just kindly have a glance, there is division of scale of pay from 1200 to 1800 to 4600. Lordship, then kindly look page 48.
Your review is dismissed on the ground of delay.
Yes, my lord.
You concentrate there. If we will allow that, then the review court will look into the merits.
Review was sought for on the ground that
We are not interested. You satisfy us on the limitation point.
Limitation and DIU.
If we will allow, the review court will go into the merits.
Yes, yes.
Okay.
yes, my lord.
So,
The delay is 2469 days.
Yes, my lord.
What explanation you have given in your review?
Explanation para 4, my lord, of page 111.
No, where is your review petition?
The review petition, my lord, that is I have annexed, my lord.
Where is that?
Page 111 of the brief, my lord. The writ petition.
where is the MA?
My lord, page 110.
110.
And the explanation,
Paragraph टा अपन question.
para 4, my lord.
कौन है?
That is respectfully submitted here that as per the law of limitation, the above mentioned DP application is to be filed within 30 days from the date of order. It is submitted here that after passing of order date 17/8/18, the same was not communicated to the applicant by the conducting counsel, and after being inquired about his case, the applicant petitioner could only knew about the order dated 17/8/18, then applied for the certified copies of the original application with all annexures, including the order dated 17/8/18, and the applicant obtained the copies on 11/11/24 and found that certain aspects and facts had not been taken into consideration, and thereafter consulted the council to prepare review.
No, this is not the explanation. How do you say that every order passed, it is communicated to the, and
You are the petitioner. You will not inquire. What is happening? Your
Yes,
counsel appeared.
That I put
then
into consider.
you
That I have to
see-
consider.
the order was not reserved. It was dictated in the open court,
My lord.
as it appears. You
My
see,
lord.
come to the page, relevant page.
87.
Yes.
87 is the order. Your counsel also appeared.
Yes.
Then,
But my lord, that was not communicated to me.
no, that is,
But it's simply my only concern is that
You don't have any responsibility. You have filed.
yes,
You have engaged a
my lord,
counsel.
I
You
do.
have argued. In 2018, it is disposed of. You slept over. In 2024, you move application for obtaining certificate
My lord,
copy.
it is a case,
Only to file the review.
my lord, it is a case of regularization. And similarly, placed person approached the CAT bench in Calcutta. It was allowed.
no, we are not going, you are challenging a review order. We found that your advocates were present, and it is not a case that when the matter was heard someday and it was reserved and delivered on another day so that you will not be aware. So very day when the matter was taken up, the order was passed, that is on 17th August 2018, very clear.
My lord,
So
I cannot
if
dispute.
your counsel has not informed you or whatever it may be, that is not that you can take step against the counsel.
My lord,
But now fact remains that there is a delay of 6 years.
my lord.
18, the order was passed and you filed the review petition in 2024.
My lord.
So, and the explanation is not
Satisfactory.
simply given that that was not communicated to you. What is the scope that every order which has been passed is to be communicated? Is there any procedure in the
No, my lord. Absolutely.
your client is to
Yes,
your
yes,
advocate is to obtain the certified copy and accordingly give you advice. So you are telling that it was not communicated. It is the duty of your advocate.
Yes.
If he has not communicated, how can it be? It's a
No, merits also you don't have a good.
Two, four,
You have
six,
accepted group D irregularization.
My lord,
And there is no vacancy in group C.
no, my lord.
So
What
therefore-
happened in merit? I submit that, my lord, that similar matter was before the CAT Calcutta bench, wherein
We will
order
come
of
to-
regulation was passed. That was challenging before the Calcutta High Court. That was also confirmed, my lord. That aspect, even though the documents relating to bench of order of the Calcutta High Court and the Cat bench Calcutta was annexed to the original application, that has not been taken into consideration.
Honorable Learned Counsel for the petition, Learned Counsel for the. This petition has been filed by petitioner Shailendra Sattar, challenging the order dated 17/8/2018, passed by the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack, in original application number 613 of 2011. In dismissing the original application, so also the order dated 6/5/2025, passed in review application number 9 of 2015. It appears that the original application was disposed of on 17th August 2018, and the review petition was filed on 11/4/2025. The ground that has been taken in the review petition is as follows. Quote paragraph number
4, 110.
page number 110. Page number 110. 111 paragraph 4 in entirety quote करते हैं. The Learned Tribunal, after considering Rule 17 of the CAT Procedural Rules 1987, which provides that no application for review shall be entertained unless it is filed within 30 days from the date of receipt of the copy of the order sought to be reviewed. And the ratio laid down by the Honorable Supreme Court in case of A. Rajendra versus Gonugunta, Madhusudan Rao and others, passed on 4/4/2025 in civil appeal number 1. So the data reported has been pleased to hold as follows. Quote paragraph number 4. The impugned order which was passed on 17th August 2018 in the original application also indicates that the prayer made by the petitioner to regularize his services with effect from 8/8/1993 in the scale of pay of rupees 950 -1500 what are also considered, and the Learned Tribunal gave the following finding. Order itself shows that the order was dictated in open court and it was not reserved, and after hearing the Learned Counsel for the petitioner, the order was passed. Therefore, the grounds that has been taken in the review application that the order was not communicated to the petitioner, order was not communicated to the petitioner by the conducting counsel, for which the petitioner was not aware about the same, and that after knowing about the passing of the order, only applied for the certified copy and the file is not, has been rightly torn down by the Learned Tribunal. In view of the impugned orders, we are of the view that there is no ground to interfere with the same. Accordingly, rate petition being devoid of legislative discussion. Yes.
Number 6. The petition was challenged the order of the law total, my lord.
Item 5 और appearance में भी noted मैम.
ये कहा ना कोई देना दी लिस्ट का
हाँ list दीजिए.
अब 4 नंबर टा कौन पास हो गई आपन को ना कहार
हाँ हमारी सीधा से our council is not with a proper uniform. That's why.
yes now is come you are
Yes.
mentioning in item number এটা 4 না 5
5.
अच्छा 5 rate
5 were disposed of. Yes.
what about 4 item number 4
Or Mr. Mahanti will argue the matter. Yes.
I have filed.
We are the opposite parties.
yes ठीक है
It's partially perfect,
हम्म
not doing the proof properly. Why are you so in hurry? You could have properly tied.
ଆପଣ ଯୋଉ ବର୍ତ୍ତମାନ ପିନ୍ଧିଛନ୍ତି ଆପଣ ଦେଖିଛନ୍ତି କେମିତି ପିନ୍ଧୁଛନ୍ତି ଆପଣଙ୍କର କଲରଟା ତା କଲର ଉପରେ ରହିଛି ଟାଏ should be one when you're practicing in high court it should be in a proper manner it should come to the before entering to the courtroom you should
In hurry.
yeah yes Mr. Mahanti
Lordship, this is the order against the Central Tribunal.
You are arguing 4 or 6?
4.
yes please argue.
Page 113, Your Lordship. That is 8/5/2025, Your Lordship. The only order, Your Lordship. Page 114, because they have written of the paragraph 1, Your Lordship. Because only 2 is my submission, third is counter, and next part is fourth with the or. Having heard on counsel for the respective parties, we have varied the pleadings made in the way counsel agenda and the documents filed with in support thereof.
no you come to paragraph number 4
Yes, sir. Fourth, they have in the foregoing facts noted above and reading the various conditions stipulated in the MSCB scheme, we find no illegality or irregularity in the decision-making process of not granting the applicant the third financial obligation under MSCP. We have also examined the case in hand with reference to the facts of the case of Naresh Kumar Verma, Supra, that is the Jabalpur bench case, Your Lordship, relied on by the applicant and find that the said case has no application because the applicant therein was denied the third MSCP due to imposition of punishment of censure. Therefore, taking into consideration the date of initiation of proceedings, imposition of punishment of censure, etc., this tribunal directed to granting the said benefits under third MSCP, whereas the facts of the present case is totally different, distinct to the case relied on by the applicant. And
I think in the counter affidavit
yes, sir.
they stated that you are due for third financial obligation
Yes, sir.
23/11/2013
Yes, Lordship.
but they stated that why you are not given that has been
You were suspended from 6 to 2014 to 28 to 2014 and facing a criminal case. So that
Yes, sir.
period will not be counted.
The MSCP I have eligible in 23/11/2020, no, 2013, Your Lordship. Thereafter, 6 to 2014 is come into picture, Your Lordship. They have stated why they have not given because of 15/5/2013, Rule 16 proceedings there, Your Lordship. Minor proceedings is there. That's why they have not given. And in culminative, they have
you come to the counter affidavit you have filed which paragraph is relevant
Your Lordship,
the reason which has been given for not granting you that third MS
yes, Lordship.
which paragraph of the counter affidavit is relevant for that purpose?
Your Lordship, page 53, Your Lordship. 53.
53
sir.
yeah
1, 2, 3, 4.
the reason which has been given
8 lines, sir. Yes, of third MSCP of the applicant was due from 23/11/2013 on completion of 38 of continuous regular service, but the applicant was proceeded against under Rule 16 of CCCT rules 1965 on 15/5/2013. Due to that issue, they have
Now come to page 55. Para 6 first one.
Yes, Lord.
Para 6 first one.
Yes,
That
Lord.
in reply to the content.
Yes, Lord. It is only submitted that there was no discrimination against the applicant on granting third financial obligation under MSCP scheme with effect from 23/11/2023.
The reasons for not granting the financial right.
Granting third financial obligation has been elaborately discussed in brief history of the case. This is the brief history that is the
Read down. The applicant was
the applicant was proceeded against the Rule 16 of the CCC Rules 1965 dated 15/5/2023.
Due to pendency of the said.
Relevant date is 15/5/2013.
Yes, yes. Yes.
And due was 23/11/2013.
Thomas for a.
Yes, sir.
Read it further.
Due to pendency of the said disciplinary proceedings, the applicant was not granted third MSCP with effect from 23/11/2013. Before finalization of the Rule 16 proceedings, the applicant was placed under suspension on a period 6/2/2014. Your Lordship. My submission is, Your Lordship, on dated 23/11/2013, Rule 16 minor penalty proceeding is there, Your Lordship. As for the MHA rules 64, I have annexed that order.
What is your reply to that in the rejoinder?
Yes, Your Lordship, I have given.
What have you stated? So let's see.
Page. Annex of 3 page 102, Your Lordship.
No, see paragraph को आसम जो say you ये टा deal ही चाहिए.
Your Lordship, Your Lordship, kindly page 104, paragraph 5. The respondents have contested the way by filing counter that Rule 16 charge sheet was framed under CC Rule 65 against the applicant for imposition of minor penalty of 15/5/2013, which reached its finality on 12/1/2015 by imposing penalty of recovery of 1,19,902 from the applicant. It is also a rule that is the minor penalty charge. Further, during the pendency of this minor penalty proceeding, a criminal case was initiated against the applicant and he was placed under suspension. During the period at the end, the said criminal proceeding is still pending in the court of CJ Bhubaneswar. The respondents have also unnecessarily cited about the minor disciplinary proceeding, other disciplinary proceedings is there. At that point of time, relevant time 23/11/2013, that is the Rule 16 proceedings is there. As per the, I have also see they have taken into account that the object they will see.
Where is Rules 16? Show us. Rule 16.
I have also given annex of 4, Your Lordship. Rule 16, the penalties.
Rule 16.
Penalties of fine.
One. मतलब 16 टा कौन कर ले? Rule 16 टा?
Rule 16, where the punishment
you have not given Rule 16. Hurry that.
No, not punishment of penalty. 11 I have given.
No, Rule 16.
Rule 16, Your Lordship. Lordship, kindly see that if it is Rule 16, that the promotion ability that can be given in view of the.
See what I mean? The क्यों चलता? अरे आना omni क्यों नहीं मुझे?
That judgment I have given in the tribunal, Your Lordship. The double wage.
Rules এটা তো judgment है ना?
Yes, এটা rely করছেন the government of India.
हमें rule 16 देखो because Rule 16 is relied upon.
Have you not brought the book?
Do you have with you?
I have not got it. Rule 16.
The entire point has been discussed on Rule 16 and you will not bring the textbook.
Do you have with you?
Yes, sir.
Do you have with you? Oh, thank God. What do you have?
I would put up this matter next week. Yes.
Six.
May I please, Your Lordship? In which case the petitioner have challenged the order of the law central the tribunal, my lord, under Annex 3, my lord. The petition is a school teacher matter, and he is not eligible for the MHC scheme, my lord. So let's see, can't see the annexed for 4, my lord. Here the clear mentioned that my lord, that school teachers are not eligible for the MSc scheme. He eligible for the CSC scheme, my lord. Annexed for 4, my lord. Page 46, my lord.
You have filed original application, you have filed the counter affidavit.
Original I have filed annexed 1, my lord.
Please listen to us. You have filed the original application and the counter affidavit. Come to paragraph number 4 of the infund order, which is at page number 42, internal page is 5. It appears that you have also filed a rejoinder.
After the rejoinder, I have
Where is the rejoinder copy? Why have you not annexed that? Pleadings are not complete in this one. We are repeatedly asking you that you file the entire thing.
Yes.
Now you file the OA application, you file the counter affidavit, but not the rejoinder. But the order shows that a rejoinder affidavit has been filed by you.
Let me up to brackets, my lord, I will file the rejoinder.
Yeah, let me know. This writ petition has been filed by the Union of India and others, challenging the order dated 17/4/2025, passed by the Land and Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 31 of 2022. On perusal of the order, it appears that not only the petitioners filed the counter affidavit, but also the opposite party, number 1, filed the rejoinder affidavit. But the rejoinder affidavit has not been annexed to the writ petition. Land Council for the petitioner seeks for an adjournment to file the rejoinder affidavit. Put up this matter as played for this matter after ensuing puja holidays.
Item 7.
May I please your lordship, and to BC lordship. Here in this case, my prayer is to quashing of Annexure 7. That is the impugned order passed by the CAT Cuttack lordship. Lordship, in this
Mala,
case,
it is item 7, man.
Yes.
They didn't serve the copy where they are praying against the railway, and they search from LMS they serve the state council, but not to our office. But prayer is against us. They didn't serve the copy for railway.
Madam,
lordship undertaking, this legal undertaking also giving that after admission we serve the copy to the.
No. No question of undertaking. You have you not served a copy on the Union of India?
Sir.
Why?
Lordship, in this after admission.
No.
In the cause title, they have written the Rajani Rawal versus State of Odisha. Into Bithre with the Union of India, cause title Union of India.
In the writ petition itself, the opposite parties are Union of India and Senior Divisional Electric Engineer Railways. So for all these, I think you are appealing.
Yes.
Yes. So give him copy. The Land and Council for the petitioner. What is your good name, ma'am?
Yes, Mishra.
S. Mishra. Appears to virtual mode. And when it was pointed out by Mr. Pari and Deputy Solicitor General that the copy of the writ petition has not been served on Union of India, the Land Council for the petitioner submit that suits of the copy of the writ petition. During course of this week, you serve it. Okay. So that matter can be. Yes.
May I pray, lordship, can I know the name of the Land Council of the Union of India?
Whose name you want to know?
Lordship Pari, sir. Name.
Mr. Padi, you do not know you are practicing or what is this? You collect the name from this is not the way we mean it is asked in the that you Deputy Solicitor General name you are not aware. And
in the office of Deputy Solicitor General, you have to serve copy. Okay.
Unfortunately, yes, all right.
Item 9.
My lord, this is regarding Sambalpur cultural link.
Land user cases by some other bench.
Okay.
9, 11, 14.
Yes. 9 ଗୋଟେ ତାପରେ
11,
11 ତାପରେ
14, 1, 4.
14 ତିନିଟା
Three matters, my
So there is some other bench in which one of us Johnson, but part of it.
Obliged.
Recently cloud out. Yes.
Item 10.
Wait, please allow. Order at Annexure 7 of the CAT. That's at page number 93 is under challenge file. The operative portion is paragraph 9, page number 99. The petitioner had challenged the rejection of their application for compassionate appointment, and it was rejected on the ground that by the time of consideration of the application, a ban was put by the ministry itself, Ministry of Jal Shakti. So in that regard, the application could not have been considered. However, the learned CAT has directed to consider the application of the petitioner. While ordering so, the learned CAT has relied on the clause 6C of the DOPT circular 2013, my lord. That circular I'm providing, my lord. However, my lord, the 2013 circular is not applicable. Even though the 1998 circular is applicable, even though the clauses of 98 and 2013 circular are not very different from each other. However,
Just finish. Aude is relying on that some
clause 6C.
This is 6C means this ban a 5% of you come to paragraph number 8. Internal page is 7, but running page is 99. Even though the recruitment to those posts were kept on hold, but by virtue of exemption provided under 6C of the DOPTOM, dated so and so, 5% of those posts should have been filled up through compassion. This thing put us like
this we have given in our counter affidavit, my lord. Lordship may come to page number 89.
89. Yeah.
Scheme for compassionate appointment under the central government determination of vacancies for. The understanding is directed to say that the existing scheme for compassionate appointment is contained in this department so and so. As amended from time to time, para 7D of this OM provides that compassionate appointment can be made up to a maximum of 5% of vacancies on direct recruitment quota in any group C or D post.
So that was considered. How do you meet it?
Last paragraph in 89, just say 89, last paragraph. While existing ceiling of 5% of the compassionate appointment may not be modified, but 5% ceiling may be calculated on the basis of total direct recruitment vacancies of Group C and Group D posts, excluding that have been risen in this.
That
The
was
total
considered
vacancy available for making direct recruitment would be calculated by deducting the vacancies to perform.
Well, that was considered. After that, their representation was rejected. Said rejection order was challenged before the CAT.
Yes.
CAT went into the 2013 circular clause 6C. However, first minor clause 2013 circular is not applicable because this was a claim that was made before 2013. The date of the employee actually went missing on 2003.
The reasoning is page 99.
Page 99.
Right.
Page 99.
Right.
Right.
Really read that entire paragraph. Just
Right.
right.
It is quite evident from 6C that the ban orders on filling of posts issued by the Ministry of Finance is not a roadblock for consideration of cases of compassionate appointment. Therefore, the action of the respondents is not as per rules and illegal. Further, it is seen that 2,979 posts which were lying vacant were abolished in the year 2022. Even though recruitment of those posts were kept on hold, but by virtue of exemptions provided under clause 6C of BOPT OM dated 16/1/2013, 5% of those posts should have been filled up through compassionate appointment. It is also not the stand of the respondents that the work search employees are not regular employees. The employees who were or are working in the work search establishment are regular employees. It is not the grant of compassionate appointment to the dependents can only be done in work search establishment only. The case of the applicant number 2 could have been considered against vacancy position in the whole respondents organization.
Read further.
Read further.
In view of the above discussions, the action of the respondents is not considering the case of the applicant number 2 for grant of compassionate appointment, and the rejection by letter dated 3/3/2020 is arbitrary, illegal, and non-application of kind, and therefore the same stands quashed. The respondents are directed to consider the case of the applicant number 2 for grant of compassionate appointment by constituting CRC and pass a speaking order to be communicated to the applicant. The entire exercise shall be completed within a period of 6 months, who is allowed with above direction.
So this DOPT is dated 16/1/2013. So what is your case why it is not applicable? This is
Allow me just a moment to explain the series of circumstances. Like this one Prafulla Chandra Rao, who is the father of OP number 1 and husband of OP number 2. He went missing in 2003. My lord, may come to the dates.
This 5% thing is mentioned in the page 89. That is dated 14th June 2006.
6.
Yeah.
That will be applicable.
Yeah.
I'll explain.
Applicable. He was found missing.
He went missing in 2003.
Yeah.
2003. After that, there was no communication from the OPs regarding compassionate appointment. They did not make any application because it was our communication in 2009. They made 2009. We made a communication to them that the retirement benefits or the death benefits that are due to them will be provided to them if an application is made to us. No application was made after that. After a period of 4 years, on 14/8/2013, a death certificate of the missing employee they obtained from a court of civil jurisdiction, court having a civil court of competent jurisdiction, and on 24/9/2014, they made an application for post-retirement benefits and compassionate appointment. 2014, that is a period went missing in 2003.
No, according to the death certificate, what is the date of death?
Date of death is 2010. Death certificate.
Let us see.
Death certificate is page number 38, my lord. Date of death is 29/1/2010.
So, by that time, this was in force. This 2006 thing.
I'll come to how 2016, how they are not eligible due to delay and lapses. There is Supreme Court that directly says that even if the delay is occasioned whether by the claimant itself or on the part of the authorities, a court, while exercising its jurisdiction under 226, cannot direct a consideration of application after such a long delay. It will be against the
no, that is general principle. It's a compassionate appointment, and there was some kind of delay in obtaining the death certificate. Might be that they were not aware about the person had gone missing. Subsequently, they came to know, and ultimately they filed a case, as you said, and by the order of the court, this death certificate was issued. So, fact remains that you are not disputing now that the date of death is 29/1/2010.
No.
By that time, this 2006, which provides that 5% are to be given for compassionate appointment, that was there.
Right.
So that 2006 টাকে কোন পেজ রয়েছে? পেজটা দেখুছিলাম আমকো
2006 89
পেজ
89
89 page 89 বলতো that is 14th June 2006 and death certificate death certificate now
certificate is at my page number
page
38
page 38
okay
date of death which is 29/1/2010. So rest of the things becomes immaterial once you are now taking him back to the date of death as if from the date of missing it is the date of death. So that is why this provision or this came in 2006. So that is how he is not entitled, he is not covered under this.
Earlier also he came to this court, filed a writ petition and got a direction.
The circular
What is
itself,
delay? He
the
has been-
circular itself provided that with the at least after 2 years of going missing, the petitioner, the dependents of the petitioner can come for compassionate appointment. That is the delay on their part, my lord. They knew that Professor Kumar Sahu has went missing, and after that the law provided them the opportunity to file the application for compassionate appointment after 2 years, but they did not apply. They took action only after we sent them a letter that we want to disperse your retirement.
Para 2 defects, just see, para 2 of the imbue not at page
Somebody,
94.
you see, somebody went on missing. The family members are not aware that whether he is alive or dead.
He filed a civil suit.
They filed a civil
Got a
suit,
decree.
ultimately got the decree and got that death certificate. So that is how
Then he gave representation, which you rejected. You will not pass the order. A writ petition was filed. Then direction was made.
there is a
What else
provision
you
that
did?
if somebody is not hard to be for this much of year, that is 7 years, then it is to be presumed that he is dead. So that is how they got all these things. And in 2010, the death certificate date is very specific, 29/1/2010. So the claim obviously would come thereafter. So how do you say that from 2003, when the father was found missing, they would have claimed for compassionate appointment? On what ground?
Circular provided in the law.
Compassionate appointment କେତେବେଳେ ଦିଆଯାଏ? ଜଣେ ମିସିଂ କରିବ ତାକୁ compassionate appointment ଦେବେ କି? ଆପଣ ଦେବେ କି ତାଙ୍କ?
then circular se provision thila ki diya jai paribo after 2 years semane apply kar paribo.
They were not aware that whether the father is alive or not. That is the main problem.
And a suit was filed. It was decreed that it's declared as a civil debt. Thereafter, their right accrued.
This petition has been filed by the Union of India.
Another submission on the state of West Bengal versus Department of my reliance.
All right. You are Union of India. Don't.
Work charge employee.
Work charge employee with a compassionate appointment. They will generally approve.
Work charge establishment is nobody
So passed by the London Central
has
Administration.
been abolished in the meantime. my lord.
In way number so and so. It appears that the opposite parties filed the original application. What is the copy of the original application?
Copy of the original application starts from page number 23.
Where is it? Page 94.
Acha. Original application before the so and so bench, which was registered as so and so, in which the following relief was sought for. Paragraph number 8 relief of court for this. The facts narrated in the aforesaid original application is as follows. Quote paragraph number 2. 2 of the informed order that is dated 7/2/2010. The petitioners entered appearance and filed the counter affidavit wherein the stand was taken. Paragraph 3 को देखिए लिखते हैं, है ना? After the opposite parties also filed the rejoinder affidavit, reiterating their stand taken in the original application, and the petitioners also filed a reply to the same. The London Tribunal, after considering the pleadings and hearing the land counsel for both the parties, considered what is this clause 6
Right.
in paragraph number 8, no 7, 8, 7 and 8 left as follows, 7 and 8. It is the contention of the land council for the 7, 8, 9 problem that since the father of the opposite party number 2, who is also the husband of the opposite party number 1, was found missing since 4/4/2003 as per the averments taken in the original application. Within 2 years, the application for compassionate appointments would have been filed. And since the application was filed, what is that High Court order target number?
High Court order is that kind of based on 21.
What is that date when the representation was filed, which was directed to be disposed of?
4/2/2020 High Court's order direction to
Representation
Nine,
dated
representation dated
9/12/2019. 9/12/2019.
Since the representation was filed on 9/12/2019, claiming the compassionate appointment, and since the same was not considered, the opposite parties approached this court in WPC number 2523 of 2020, which was disposed of by the order dated 4/2/2020, with a direction to the petitioners to consider the representation in accordance with law. Thereafter, the petitioners were justified in rejecting the representation on the ground of delay.
On the ground of lack of vacancy.
On the ground of lack of vacancy. Stop. We find that the opposite parties were not aware about the death of the what is the name of that person?
Prafulla Chandra.
Death of Prafulla Chandra Raut. Who was working as a Khalasi since 12/2/1978 in the establishment of the petitioner. Petitioner number petition number 2 though. Petition number 3. नहीं ये सेंट्रल वाटर ये पाखरे काम करला ना कोडी काम करला
सेंट्रल वाटर कमीशन सुपरिटेंडिंग इंजीनियर ऑफिसर
petition number 3 कर दे. And it further appears that in that connection, in connection of the missing of so and so, one FIR was also lost, And ultimately, the opposite parties have to approach the London Civil Judge Junior Division for declaring so and so as civil debt. And after passing of the judgment dated 29/1/2010, they could able to get the death certificate of says proper. And the death certificate clearly indicates that the date of death is 29/1/2010. In the এটা কেতে নম্বর পেজ আছে সে যে 2006 এটা 89 আচ্ছা in the office memorandum dated 14th June 2006, which was a scheme for compassionate appointment under the central government, it has been stated as follows. Quote for the entire quote for them. Therefore, so far as the ban is concerned, ban ta kebe asila dekhile
Plan as well.
2000 se juda dekho
Order 8/3/2018. That is at page number 19.
19
page number 19.
19. And on 8th June 2018, it was decided by the government of India that all the recruitment in Varchia's establishment of CWC may be kept on hold by all field organization of CWC until further orders. Therefore, when the death certificate shows that the date of death was 29/1/2010, which is not challenged by the petitioners, and at the relevant point of time, the office memorandum dated so and so 2006 was in force relating to the scheme of compassionate appointment. Therefore, the opposite party number 2 was entitled to get the same. We found that the London Tribunal has correctly assessed the position of law and came to finding that the non-consideration of the case of the opposite party number 2 for grant of compassionate appointment and rejection of the representation suffers from arbitrariness, and it is illegal and non-application of mine, and was the same. And further directed the petitioners to consider the case of the opposite party number 2 for grant of compassionate appointment by constituting CRC and to pass a speaking order. We do not find any infirmity or illegality in the impugned order, and therefore the petition being devoid of merit stands dismissed. Next.
As part of your lordship dictated within 2 years. Is that after at least 2 years? It is not within 2 years, it's after at least 2 years.
After 2 years.
And your submission.
Yes, next.
My submission regarding reliance on this judgment may be required. State of West Bengal versus Devabrata Tiwari.
Which one?
State of West Bengal versus Devabrata Tiwari. I have relied in the petition itself. AI to 2023 Supreme Court.
Who paragraph election?
Page number 10 of the petition, ground B.
Acha, the Learning Council for the petitioner placed reliance in the case of so and so. The paragraph to quote for the that the analysis to yes. Next.
Item 12.
The judgment is on the figure of Punjab. Asylum take it. Okay. Yes.
In item 12, there are three ways has been disposed of by the learned Central Administrative Tribunal. So, which two read petitions have already been filed and they have adjourned to 18/8/2025.
And all the cases will be taken up analogously. That is our prayer.
You are challenging which order?
Challenging the order passed and dated 3/12/2024 in OA number 379 of 2020.
Same issue.
Same issue connected.
OS.
That is 380. What is your good name, Mr. Land Council?
Paibalya Panda.
Paibalya Panda.
Mr. Paibalya Panda, Central Government Council.
CGC.
Has produced the order dated 7/8/2025, passed in WPC number 21566 of 2025, and submits that the Union of India has challenged similar orders as has been improved in this petition, and all those matters were directed to be taken up together. This matter with WPC number 21566 of 2025 and WPC number 20415 of 2027. इनका संग राशि है ना WPC टा जोटा प्रोड्यूस करना ताजे लास्ट लिखा है इटा ता संग राशि है दोनों ए मैटर टा से दीटा संग राशि है
Item 13.
I'm sorry, the matter was on Monday. It was on Monday, in fact. I missed the base. Now, this is one of such interesting cases. It's not exactly a securitization matter. Actually, initially, and the auction procedure, I paid the entire amount, got the property, said it was executed in my name. But subsequently, the original owner he filed a writ application where the bank considered that we have settled the matter, as a result of which we want to refund the money to the auction purchaser and return back the property. So, though the auction purchaser objected, the court said, no, since he's paying the entire amount, you give it back.
Where is that
Direct
order?
Huh?
Where is that order?
2017, Margaret. If ownership looks at, that order is there, page 35. pays 35 months.
So there the petitioner is the one, Sagar Agrawal.
Okay.
Who is he?
I am Sagar.
No, no, you said that the original,
Original auction purchaser.
you are the original auction purchaser. So, the Sagar Agrawal filed this petition. Are you not made a party in that?
Yes,
petition?
I was a party.
So you are hard.
Hard.
And this order was passed.
Yes.
So what is the what problem thereafter?
The Honorable Court directed that I should give back the property. They should pay me back the money I deposited.
Yes.
40 lakhs amount. They did not pay the money. I said, you return back the money, I'll give possession. They did not return back. They kept it as such. I'm in possession and they didn't return the money. But interestingly, they filed an application under section 14 before the collector to take possession. But 14 has got no application in this case. 14 relates to something else that now on section 14, the collector has now given delivery position. Collector directed bank to deposit the money before the collector. So I gave a calculation that I deposited way back about 10 years back the money. So it
you are interested in interest.
Interest and all that I should be entitled to. Now bank deposited only 49 lakhs. Collector directed you pay 50%. He doesn't have the right to say 50% or entire amount.
Which is the bank? Eco Bank.
The Lordship looks at page 56.
56, the extract of the order dated so and so.
Yes.
As per the order.
24 by the collector valuation.
Yes, sir.
He is sitting over the matter in section 14. Then he directed the bank deposited the amount 49,63,525 as per their calculation. I gave a calculation, in fact. If you Lordship to the next page, annexure 13. It was given for the collector also.
What is the interest you are demanding?
Next page, if your Lordship looks at.
7.90.
Yes.
7.6.
Next, no, the entire amount is 1,33,57,000 some odd. Collector passes on 13/6/2025. Is a case taken up today. The petitioner is absent on call. On perusal of the case, it appears that petitioner has not handed over the physical possession to the opposite party, though he was directed on 28/3/2025. Accordingly, 50% of the deposited amount has been released in favor of the petitioner. They return back 50%. So and so, intention has not handed over the person. Sir, unless I get the money, also I handed over position.
The order of this court is very clear to that effect.
Yes.
Let us come to once again this order of this court. That is WPC, you said that was disposed of.
Page 35.
Page 35, na? When counsel for the opposite party bank does not dispute the factual position that the loan amount has been settled with the borrower opposite party number 7. You are the opposite party number 7.
Yes. Bank is directed to return the
opposite party number 7 is the loan. Petitioner in the said very petitioner filed.
The petitioner, the auction has been cancelled and initial amount deposited by the auction purchaser has been forfeited. It is fairly submitted. The bank is ready and willing to refund the amount deposited by the auction purchaser along with the admissible interest.
Yes.
Okay. So your deposit amount is
only 49 lakhs. I disputed that. I said no, it can't be 49 lakhs.
No. You deposited how much?
I deposited
41 lakhs.
No, 40.
When you are the
purchase 40 lakhs amount.
40 lakhs.
Comes to 41 lakhs, but 40 lakhs amount.
Bank has to issue.
The collector actually doesn't have the power as such on section 14, but still then I said, all right, you get me the money, I'll return. Now they have taken possession. They have taken possession.
So, Mr. Naik, you will appear for 1 and 4. And bank, UCO Bank notice you. UCO Bank 2, 3 and 5.
Yes.
what is the latest order that was passed by this court in this, because the number is WPC number.
So there actually I filed a writ application where the section 14, the director for delivery person, they recalled the order. Therefore, the writ became infructuous.
All right, this petition has been filed by the petitioner, Sagar Ogwal, challenging the order dated 13/6/2025 of the collector Balashwar. और ये केस नंबर हो जाएगी जितना खाएंगे किसी केस नंबर हो जितना कौन रेटा पास होगा এটা সেই উপরটা লেখা আছে 56 রে
56
কেস নাম্বার 36 of 2022 এই অর্ডারটা
Case number, this case 36,
আচ্ছা in this case number 36 of 2022
2022.
হ্যাঁ You are aggrieved by which part of the order?
Last order,
Last one 58 no?
13/6/2025.
Please show that portion of the order.
Sir, page 58, annexure 14.
We have seen that.
Yes,
Which
yes.
part of the order you are aggrieved? We want to know.
So my grievance is, this order was passed in my absence, number one. Number two, court directed that 49 lakhs 50% when I disputed that amount. I said that I am entitled to more than 1 crore rupees as per the interest calculator. I have given details. Without adjudicating, if he is adjudicating for delivery position, he can also adjudicate that. Now he says you take 50% has been paid.
Where is that 50% could have pound?
Top manner. First paragraph. That the petition is absent on call. On perusal of the record, it appears that person has not handed over possession opposite party, though he was directed on the day, and accordingly 50% the deposit amount has been released. Bank released 50% the amount through collector.
Directing the petition, directing the executive magistrate to take over the physical possession from the petitioner and to release 50% of the deposited amount in favor of the petitioner. Land Counsel for the petitioner, Mr. Mishra, pointed out the order passed by this court in what is that order to
Page number 35.
Page 35.
Order dated
order 16/10/2017 passed in WPC number 398 of 2015, which was filed by the petitioner. Wherein it was observed that on the basis of the statement made by the bank that it is ready and willing to refund the amount deposited by the petitioner who was the auction purchaser along with the admissible interest and on his handing over physical possession of the mortgage property to the bank. The contention of the Land Counsel for the petitioner is that at the present position, the opposite party number, who is that man who has got the physical possession? He is not made a party here.
Original borrower.
So possession has been delivered already. We delivered it to bank, bank delivered to.
Possession has been delivered to the bank. which has in turn delivered to the borrower. But the petitioner has filed the calculation sheet, which is at Annexure 12.
13.
Annexure 13.
Yes,
Annexure
at page
13.
57.
To show that he is entitled to get 1,33,57,849. However, the impugned order dated 13/6/2025 has been passed without taking into account the calculation sheet presented by the petitioner. The Land Counsel for the petitioner submits that in view of the order of this court passed in WPC number 398 of 2015 on dated 16/10/2017, the calculation sheet which was filed by the petitioner was proper and justified, and therefore the collector Baleswar should not have passed the order under Annexure 14, directing the executive magistrate to take over the physical possession when the only 50% of the deposited amount has been released in favor of the petitioner. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Counsel for the state accepts notice on behalf of opposite party number 1 and 4. So far as 2, 3, and 5 are concerned, you can info banker ki action in the notice there.
Notice.
Panel lawyer with the number of panel lawyers, sir. Acha, let the notice issue requisites to be filed within a week. Matter be listed of responsible. Counter affidavit is going to be. Yes.
This is notice item 1 for judgment. Okay.
For the foregoing reasons, the review petition deserves no merit, hence the prayer made in the petition is not issued to. Accordingly, the same is dismissed.
I agree.
This review petition is also dismissed in view of the detailed judgment passed in the earlier judgment.
I agree. You're just coming.
Item 15.
Next week, my lord. Next week. You have, who is the other side?
Yes.
Have you received the copy of the writ petition?
Yes.
Mr. Mishra and Counsel hearing for the petition. 6 for an adjournment. Next week, put up this matter on such and so that is.
Item 16.
The reversing judgment. Ma'am, you are supposed to file your wakalatnama?
My lords, it has already come. I'll file it in the course of the day. My lords, in fact, somebody is waiting for me downstairs. The officer concerned was not there yesterday.
So, what is your instruction in this matter? You have received the copy of the.
Yes, my lords.
So,
My lords, the DRAT has given a judgment in our favor, relying on the law.
the reversing judgment, na?
Yes, my lords. My lords, page 87 of the writ petition, my lords, is where the finding of the DRAT in reversing.
Paragraph 10.
Yes, my lords. The only issue to be looked into as to whether any valid mortgage was created in favor of appellant or not. Undoubtedly, lease was created in favor of Miss Srimati Gayatri Devi by the CDA on 10/4/97, wherein the relevant paragraphs are so and so. Provided that the lessee will not be entitled to sublet, transfer, mortgage, then my lord, the second proviso, provided further that
Devi is the petitioner, writ
Yes, my
petition.
lords. She is the personal guarantor as well as the mortgager
Yeah.
on behalf of the borrower. Provided further that the property can be mortgaged in favor of state government, central government, scheduled nationalized bank, life insurance corporation, and such other financial as security for the loan advanced by such organization for the purpose of so and so, my lords. Then, my lords.
Purpose of construction.
Of the house. Yes, my lords. I'm not. Construction of house. My lords, primarily, first they took a housing loan from the State Bank of India and then extended that mortgage to a CC loan. That mortgage is finds place in this writ petition at page annexure 4, where she has extended the mortgage. Annexure 4 is at page 26. Lords, page 26, my lords, where she has extended that to the CC loan along with the home loan. My lords, a permission, when going back to paragraph 88, para 11, a permission was granted in favor of Gayatri Devi when it was stated that CDA has no objection if Gayatri Devi avails loan from the financial institution from her employer by mortgaging the above plot for construction of the residential building. Then, my lords, para 12, certificate was issued by the Secretary, Cuttack Development Authority, that so-and-so has got no objection if so-and-so avails loan from any financial institution by mortgaging for construction of a building at Bidanasi. Therefore, the lease was executed. My lords, I think there's some typing error in this petition.
Paragraph number 17.
Yes, my lords.
Concluding paragraph.
Yes, my lords. Having considered submission made on the basis of discount, I consider that learned erred in finding that the permission required was not obtained. My lords, they have gone also on the law of approbate and reprobate because she has given an affidavit to the effect, which has been quoted. I don't have it today on me, but it has been quoted at paragraph 88. That according to so and so that the aforesaid property can be mortgaged in favor of state government, central government, national bank, that I am the owner in possession of the above said property and hold clear marketable title in favor of which equitable mortgage can be created, that in the event if the loan proposal shall be found defaulted, then it will open for the bank to take the said land for purpose of recovery, and in the event nobody of our success included, I shall prevent the same act. My lords, today they stand and say that there's no specific this from CDA permission, and therefore the mortgage is bad, so we cannot. And that is what, my lord, the PR
has been taken.
My lords,
What amount he has availed?
as on date, it's more than 1 crore.
1 crore.
More than 1 crore. They had earlier,
Which year? Which year?
my lords, it's almost 18, 19 years back. So facts are, in
He has
fact,
not paid anything.
No, that's not the question. 40 lakhs is the loan.
yes.
And it's 4 euros will get it. And
4.
I don't have the details, my lords, today on him. But
Para 14 above the impugned judgment, read it, you get everything.
yes, my lords.
Read it.
Yes, my lords. One cash credit.
Read it, the full paragraph, read it.
2 loans, 1 cash credit and 1 HBL were sanctioned by the housing board loan by the secured creditor in favor of Radha Kishan Jeevan Kumar, who was the husband of the petitioner. Total amount was 49.98 on 2006, whereas the equitable note secured was created. Letter of confirmation for extension of mortgage by deposit of title deeds was signed by Gayatri Devi, and she herself had submitted an affidavit on 30th June, wherein she stated that she intended to create an equitable mortgage in favor of, in respect of drawing number so and so, of plot number so at Bidanasi, which was allotted in her favor. She is the owner in possession of the property. Then applicant cannot be permitted to reside from her own admission. Principles of approbate and reprobate would apply against her. Reliance is placed upon judgment of R.N. Gosai versus Yashpal Dhir. A certificate is issued by 1990. Records show that the secured assets were handed over to Gayatri Devi Agarwal, and the authority has no objection if she avails loans from any financial institution. Subsequent thereto, loan was sanctioned to Radha Kishan Jeevan Kumar, who is the husband of the petitioner, my lords. The loan was sanctioned on 5/10/2006 with subsequent issuance of no objection certificate by the authority. Lease deed was executed on 10/4/97 by the CDA in favor of so-and-so, wherein a specific provision was made in 2 and 2B as quoted above, wherein there's a specific bar to that effect that lessee shall not be entitled without the previous consent of authority. Further, mortgage can be created in favor of the bank for the purpose of construction. Further, in case of breach of transfer, without obtaining the previous consent of the authority would be able to cancel lease and take back the possession. After execution of lease deed, Srimati so-and-so admittedly submitted an affidavit before the secured creditor, where she said she is the absolute owner of the land bearing the lessee of the same. Now she wants to withdraw her own admission just to grab public money, which is not permissible, as laid down in R.N. Gosai versus Yashpal Dhir, where the apex court has specifically held as under. Law does not permit a person to both approbate and reprobate. This principle is based on the doctrine of election, which postulates that no party can accept and reject the same instrument, that a person cannot say at one time that a transaction is valid and thereby obtain some advantage to which he could not only be entitled on the footing that it is valid and then turn around and say it is void for the purpose of securing some other advantage. According to Halsbury Laws of England, 4th edition, after taking advantage under an order, for example, payment of cost, a paid party may be precluded from saying that it is invalid and asking the same to be set aside. At one point, Gayatri Devi submitted that she is the absolute owner and entitled to mortgage, to transfer the land by creating equitable mortgage. And after enjoying the said facility, tried to reprobate the same by challenging the transaction which was at her own initiative, which is not permissible under law. Accordingly, a valid mortgage was created in favor of the secured creditor. Having considered some submission made by the learned counsel of parties on the basis of discussion, I am of the opinion that learned DRT had erred in recording a finding that permission required from CDA was not. The findings recorded by the learned DRT are perverse and against record, which are liable to be set aside. Appeal is allowed.
What is the order of the DRT?
DRT
Page number
32.
32.
I've given neat copies.
Well, as I have been given a copy which is not the same.
Annexure 7.
Annexure.
And if we come to the paragraph number 8, because that is the concluding paragraph.
Yes. Though the contention of the appellants are that the scheduled property is leasehold property and it cannot be mortgaged without permission of the CDA, and in this case, the respondent bank has not taken any permission from the CDA before taking mortgage of the property. The respondent bank has submitted that they have taken permission from the CDA, but they failed to file any documentary evidence to that effect. In the aforesaid circumstances, it is evident that there is no permission obtained from the CDA by the respondent bank, and without permission from the CDA, the property cannot be taken as security. In this case, the contention of the applicant is that lease deed clearly shows that there is a provision of mortgage, sublet, or otherwise create any encumbrance, and the contention of the respondent bank that scheduled property is used for commercial purpose, but the municipal receipt shows that the scheduled property is used for residential house only. Further, the contention of the respondent bank is that mortgage is valid, and the contentions of the appellant is that
Next question.
in the above circumstances, the acts of the respondent bank is not valid under law, and hence the steps taken by the respondent bank under Securitization Act hereby set aside, and the respondent bank is directed to take steps to dispose of the OA within 3 months from the set date. The observation in the further essay is allowed, each party shall bear their own. But there are two loans now. One is the loan obtained by this present petitioner for construction of the house. Because you also knows the scheme of the development authority is to provide shelter to people, and therefore he has, after availing the loan, he has taken permission from the CDA, and loan was sanctioned, and she has constructed the house. And that loan, the petitioner has cleared. So I have given the document also. Loan has been cleared, and the document was written to me, and everything was there. It appears my husband, who is running a business, he has taken an affidavit. I disputed that, but on record, the affidavit is there, saying that this loan is extended. The document which the bank relies on is also an extension of the list. But the point at issue is, clause clearly says that for the construction purposes, loan can be sanctioned by the CDA, by the any financial institution or bank by obtaining permission from the CDA.
Have you got the permission there?
I got the permission for construction loan.
No, not for construction. For
Here,
mortgage.
no permission. Here, no permission. I have not applied for at all. This is the commercial loan taken by the firm of where my husband is one of the partners. So there, this letter has been obtained to show as if that permission was extended here. That mortgage was extended here. But it is a commercial loan. There cannot be an extension of a loan which has been granted.
In whose name that property actually stands? Then?
My name.
Right.
That's a residential house. My name. The property was allotted to me, and I obtained loan after taking permission and constructed the house.
In the husband, he was taken the loan. Your signature is not there.
He's not.
But you have furnished an affidavit.
She is the personal guarantor.
Furnished an affidavit.
She's the guarantor, Manoj.
That affidavit, the learned DRAT has taken note of and said that mortgage is valid. But there cannot be mortgage cannot be valid because of the term in the lease deed itself. In fact, Miller, during pendency of the securitization proceedings, I have filed an application to implead the development authority as party. That application was not considered. That was just slide down. That was not accepted. And since
you first answer whether you have given the affidavit.
I have said that it is manipulated, but then it's too late for me to say now. But before the DRT, I have said that I have not given any such affidavit.
Where is that line that this affidavit has not been given by you?
Bank I have said that bank has managed. I'll just
no, the finding of the DRT, you said that was also.
No, in finding nothing was there. Finding was in my favor. DRT has said the finding was where the mortgage was not valid.
My lords, even at page 26, that extension mortgage, her signature is there at page 26 at the bottom. I'll produce the affidavit.
Is it contingent upon the bank to obtain the permission from CDA?
No, it is the borrower to obtain the permission.
Yes.
And the case can be adjudicated only in presence of the.
But the order of DRT looks like it is the bank who is supposed to get it. That it looks like. But the valid permission from CDA was supposed to be obtained by the bank while accepting the mortgage.
Your Honor, there is one judgment of Honorable Supreme Court in such a case where the property was a nodule property. Nodule property is also a leasehold property, and there the Honorable Supreme Court has said it's a bank to do all those things.
Well, in that case, the distinction is the lease had expired.
No.
Yes, my lords.
Yes, that was.
You have not given me a copy, but.
You kindly see here, last page 777, paragraph 48, 1. Indisputably, the property in question, that is premises number so and so, is a nodule land governed by the Government Grants Act, and the property was given on lease by the state of UP to Mrs. So and so, and second time the lease was renewed in favor of so and so and so and so for a further period of 50 years, which was valid up to such. During subsistence of the leasehold interest was transferred in 1945 in favor of ABP Company, and on the basis of the said transfer, a lease was executed in 1949 by the state of UP in favor of ABP Company for the remaining period of lease, which expired in 1987. As against the loan taken by the company from the bank, a mortgage was created in respect of the property by the company in favor of the bank. The lease in respect of the leasehold interest in the property admittedly expired and such and so. The mortgage so created by the company in favor of the bank in respect of nodule land without the sanction of the state of Uttar Pradesh in terms of the lease is ab initio void. Hence, no right was created in favor of the bank by reason of the said mortgage. Consequently, a mortgage decree obtained the bank on the basis of settlement in the absence of and behind the back of the state of UP could not have been enforced against the state. The subsequent proceedings of transferring the decree to the Debts Recovery Tribunal and again passing an order of auction of sale of the property on the basis of settlement is wholly illegal and without jurisdiction. The appellant bank has no right, title, or interest in the property so as to claim a right of conversion of the property into a freehold property. The impugned notice issued by the state of UP directing resumption of the property is legal and valid and cannot be quashed at the instance of the bank. For the reasons supposed,
the writ petition has been filed by the petitioner challenging the order dated 17/7/2025, passed by the Land Debt Recovery Appellate Tribunal, Kolkata, in appeal number 295 of 2018. In setting aside the order dated 10/10/2018, passed by the Land DRT Cutter in essay number 36 of 2016. Period the impugned judgment. The Land Council, Land Senior Advocate appearing for the petitioner, place reliance in the case of State of Uttar Pradesh and others versus United Bank of India and others, reported in 2016, bracket Bharat 2, Supreme Court cases 757. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. This Mamata Tripathi, Land Council, who has instruction to appear for the State Bank of India, submits that she will file Wakalatnama by next week. For
What today itself? Course of the day.
During course of this week, during course of this week. And some time will be granted to file the counter affidavit. Put of this matter after ensuing Puja holidays.
Yes.
Puja holidays, great day. IN number 1440 of 2025. There shall be stay of operation of the order. dated so and so, 17/7/2025, passed on so until further orders. Yes.
My lords, once stay is given, generally the matters do a disappearing act here.
No, I agree with you.
My lords, kindly then give a date and issue notice also on that.
You can get the date in the evening hours, because the courtmaster has to see that on what date, how many cases we have posted. It will go after Puja holiday. You want the date of the.
Yes, my lords, because since my lords
that's
is
all right,
paying the matter.
But please see in the High Court website. You'll get
Yes,
it
my
in
lord,
the
we
evening. The other parties, this Mr. Rao.
Yes.
I think notice has to be issued to also this 3, 4. They are to you are to file the requisites for them.
Yes.
Jeevan Kumar Agrawal is opposite party number 3, and Radha Kishan Jeevan Kumar is the opposite party number 4. Like them. Requisites for issuance of notice on opposite party number 3 and 4 should be filed within a period of 1 week. And no notice is required to be sent to opposite party number 5 and 6.
Give the name of your briefing counsel.
Mr. B.K. Mahanti.
B.K. Mahanti, along with B.K. Mahanti.
I'll take along with Mahanti.
He was here, just he was called.
Yes.
Item 17.
But the order under the section 14 was passed by the judicial magistrate Kendrapur, and it so was. And thereafter, the some bank requested the superintendent of police Kendrapura to for deployment of force. To take
Who are you? Who are you?
Bank.
The annexure 2, page 19, the superintendent of police asked the authorized officer by giving the calculation sheet to make the deposit 1,26,000 for deployment of force for maintenance of law and order while taking the physical possession. Then the twice date was fixed by the page 21 and 22. The first date was order was passed by the.
Have you deposited the amount?
Yes, after deposition and after depositing the money, on 5/8/25, the superintendent of police passed the order directing the reserve inspector and the IIC Nikrai police station to for deployment of force, and the date was fixed to 8 August 25 for physical position. Just on the previous day night, the reserve minister intimated that there will be no force, don't come. Postponed without any written communication. Reserve inspector.
Okay.
Then again on the next page 22, 16th August, again order was passed by the superintendent of police Kendrapura, and the date was rescheduled to 21st August. Same thing is happening.
Instruction date
there may be some problem in their end. Law and order problem. Force may not be available. We don't know.
The writ petition has been filed by the petitioner Canara Bank with a clarification to the superintendent of police Kendrapada, opposite party number 2, to take immediate steps to fix a date and to extend protection to the
authorized officer as well as the
authorized officer
to
the
subordinate officer and
subordinate officer and bank official by deploying adequate force for maintaining law and order while taking physical possession of the secured asset under section 14 of the Surface Act 2002. The Land Council for the petitioner placed the order of the land and CJM Kendrapada, passed in this case number 12 of 2025.
It was directed to
Payment.
compliance within three months.
And it is stated that where is that order regarding deposit of the money?
Annexure 2.
Acha.
Annexure 2, page 19 and 20. Calculation sheet 20,
As
19
per
is
the order passed under Annexure 2 series, the petitioner bank has already deposited 1,26,208.
208.
With the superintendent of police, with the opposite party number 2, whereafter 2 letters were issued, one on dated 5/8/2025, directing the IAC so and so you upar likha hai ji, fixing the date to 8/8/2025 for deputing the police officials for taking over the position. So also on 16/8/2025, fixing another date
21st
to 21st/8/2025 for the same purpose, but on both the occasion, the petitioner was informed by the police officials that there is a problem for which the courts are not available for the purpose of taking over the position. The Land Council for the state has received a copy of the writ petition and seeks some time to obtain instruction regarding fixing a specific date so that the process of taking over the position of the property in question and handing over the same to the petitioner bank can be carried out. Of this matter. Next week, we have to date and Kendrapada kon dasara be Kendrapada Gajalakshmi hai na.
I'll take instruction from them. What time for?
ଆପଣ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ ଅପ୍ କରିବେ ଇଏ ପରେ ଆର ସପ୍ତାହରେ ଗୋଟେ ଡେଟ୍ ଦେଇ ଦିଅନ୍ତୁ ହେଲା।
You are taking the money, why don't you employ home guards? Get it done. You're taking money for that.
If see you the persons say you ye criminals गुड़ाक थिले that is a different authorized position of say you notorious criminals they are not now so they have gone, so there is no problem. Yes, next week we are taking up this matter. We are taking up this matter on 24th, 24/9/2020. Yes. Next.
Item 18.
Which order was not complied with?
Lordships, order dated 12th May 25 at Annexure 1, page 18, Lordship. Operative portion is page 18.
Page 18.
Yes, Lordship.
According to dispose of the writ petition with the observation that after removal of the standing grounds, immediate steps shall be taken for field verification and a detailed demarcation by the authority concerned with prior written notice of this answer to remain present at the time. After supervision of the report, the authority find that any land of the petitioner as has been mentioned in so and so. ବର୍ତ୍ତମାନ କଣ standing crops remove ହେଇଗଲାଣି?
Yes, Lordship. It was removed in June 1st week, Lordship. And 2nd June, the petitioners again wrote the Tahsildar to effect the demarcation.
Where is your letter?
At Annexure 3, page 24.
Annexure 3. All right. Take instruction on this matter. This content petition has been filed for non-compliance of the order dated so on. So, while disposing of the writ petition, the following order was passed. Operative portion of the order reads as follows. Court for the duty, paragraph to 9 সেটা actually last page number 18 আছে না? The government has been taken in the content petition that who paragraph nature the
Para 2, Your Lordship. Para 2 of the petition.
para 2 না এই crops removal ହେଲା ପରେ ଯୋଉଟା ସେ ତ para 2 ରେ ଆପଣ ଅର୍ଡରଟା କୋଟ କରିଛନ୍ତି
Para 6, Your Lordship.
para 4
Para 6.
Para 6.
Communication of the.
अच्छा government has been taken in paragraph number 6 as follows. है ना? Including your 2 copies once for the Land Council for the state has received the copy of the content petition and seek some time to obtain instruction put of this matter. Yes. Next.
Item 20.
Sorry?
No, it's all right, but we have passed the order, just take the instruction. That Rairangpur submitted that the appellant was in Rairangpur up to 24/1/2013.
From Baripada.
And thereafter, he was shifted to Circle Jail Baripada. So now the instruction has to come from Circle Jail Baripada. What is your instruction?
What is it? From input 3/22, you have transferred to Billy Potnaik open areas from Damjari. And on 4/22, and again the return to Circle Jail Baripada on the 5/22. And I will on inquiry.
So Bartman achhi seat na? Currently is mentally sound. Okay. So now, since no one is appearing, so we have to engage somebody so that at least he can file an application for bail. Huh? No, right. We have to engage somebody. We are mentioning that Prem Kumar Mahanti is now in state panel. It is the Land Council for the state has produced the written instruction received from Senior Superintendent Circle Jail Baripada, which shows that the petitioner is in the Circle Jail Baripada and is mentally sound and physically fit. The report is taken on record. Since it is stated that Mr. Prem Kumar Mahanti, advocate, is who was engaged in this case by the legal aid, as the legal aid counsel to conduct the appeal, is now in state final. So is engaged as the SAU least I'm the serially query portion. So जो जाए सर्ची तक करो एडवोकेट को ना दे रहे है ना बाकी ऑर्डर अच्छी तम कम्युनिकेट करिवे से एडवोकेट को डेट टा फिक्स अप कर दें तो नेक्स्ट वीक रे so that he will appear and he will file an application for bail. Yes, next.
Item 21.
So, first, one counsel was given, appointed. She did not appear. We appointed another counsel, amicus curiae. She is also not appearing. Now, third counsel is to be engaged. Non appears. The man is alive or no? Or what is the status report? Huh? Have you obtained the report? You obtain the report, the well-being, this is, non appears for the appellants. Suppose then the respondent who engaged as the counsel for the appellant, the land counsel for the state shall obtain instruction regarding the well-being of the appellant. Year ସେତେବେଳେ ଥିଲା ପ୍ରିଜନର୍ସ ପିଟିସନ ଯେତେବେଳେ ଫାଇଲ ହେଇଥିଲା ସେତେବେଳେ ସମ୍ବଲପୁର ମଣ୍ଡଳ କାରାଗାର ଲେଖା ହେଇଛି ସର୍କଲ ଜେଲ। ତେଣୁ ଦେଖନ୍ତୁ କିଏ ଅଛି କି ଆଉ କୋଉଠି ଯାଇଛି କଣ ହେଇଛି। ପ୍ରିଜନର୍ସ ପିଟିସନ ବାହାର କର ଦେଖିଲେ ନା ଏ ସାଇଡ ରେ ଲେଖା ହେଇଛି ସିନିୟର ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସର୍କଲ ଜେଲ। ନେକ୍ସଟ after vacation करिए। नित्यानंद पंडा ये टुडे कौन अपना नागुर तो ना अच्छी ना सर मु आज and you have got the paper book no माने कौन पेपर बुक तो ही अपन नेबे ना कौन नो कौन। So how many?
Why have we not moved application for bail?
Are you aware how many years he is in custody?
Custody means
2014 April.
2024.
Huh? Sorry?
17/6 14.
No. The man is in custody since 3/10/2024. Not aware. This final form indicates his name is Rama Kishan. Final form indicate that he was taken into judicial custody on 3/10/2012. And during trial, he was all along in custody. He was produced on that is the trial court record. Pakhi 13 ବର୍ଷ ହେଇଗଲାଣି. You file a bail application. How many murders have been committed here?
You have no idea.
No idea. One to record. First
because he was doubting that the wife has got some illicit relationship.
You have to give importance to amicus curiae brief more than the personal brief. Because you are appointed as a friend of the court. You don't want to be a friend of the court. Friend of the court has a larger responsibility.
Don't think that when the brief is entrusted to you, you are only to argue at the final stage. You have to consider that how many years is in custody.
Just a minute. ପରଦିନ ମତେ 4ଟା ବେଳେ ଫୋନ କଲେ ଯେ ଆପଣ ଆପଏଣ୍ଟମେଣ୍ଟ କରାଗଲା
ପହରଦିନ କରାଗଲା
ଆଜ୍ଞା
ଦେଖନ୍ତୁ Mr. Nityananda Panda advocate is present. Let a copy of the paper book be handed over to him. Receive it appears that the petitioner is in judicial custody since 3/10/2012. It appears from the final form as well as the order sheet of the land and trial court that the appellant is in judicial custody since 3/10/2012. Mr. Panda submits that you will file an application for bail. Kali bhitar file karon to move karon. Put up this matter on such and such date. In the meantime, the land counsel for the state shall produce the custody certificate as well as the well-being of the yeah. Next.
Jail conduct also.
Item 23.
On 15th of September, an order was passed by which had referred to the amicus curiae.
What is the years? You have received the paper book?
No, just day for yesterday only I was informed. Just day.
Same order for the custody they leki jantu 16/6/2011. Hala? 16/6/2011 custody.
Mahapatra, you would move up to
I will do.
Custody certificate. You have to produce the custody certificate in this. Yes, next.
Item 24.
सोमवार पेपर बुक
हाँ नहीं सेम डॉक्यूमेंट पेपर बुक नियंतु आधे ऑर्डर देखंतु ट्रायल कोर्ट रेकॉर्ड रे ऑर्डर हेची ए जो फाइनल फॉर्म दउ आधे लिखंतु 7/10/2011 पोस्टोडी बाकी से फाइल करिए फाइल बाय मैक्सिमम बाय डे आफ्टर टुमारो ओके यस custody certificate also immediately obtained no next week ताकू ईमेल पठेगी नहीं कौन इमीडिएटली काउंट ये कर दबो नेक्स्ट
Item 25.
ये विषय के एंगेज करा गला ये कोड रही गले कोन हां you are null in consult yes madam you also position so have you received the paper book
Yes, today I have received.
Mr. Nalin Kansau is present submitted that he has received the copy of the paper book बाकी ये ट्रायल कोर्ट रिकॉर्ड भाग में the man is in custody since 16/12/2008 filed on the bail application ହେଲା 16/12/2008 ମାନେ ପାଖାପାଖି 15 ବର୍ଷ 16 ବର୍ଷ ହେଇଯିବ ଆଉ କିଛି ଦିନ ପରେ ବୁଝିଲେ ନା ତ
file it within 2 days so that we can take it up.
Yes, next.
Item 26.
Mishra. But they are not shifted. The report again. Land Council for the state has produced a report obtained from Senior Superintendent Katar Chaudhwa, which shows that appellant number 1, Anu Behera, is dead. The death certificate has been also filed. Not that omnero. Impeachment is Panu Behera. So that so far as Bimba Behera is concerned, the custody certificate has been produced, which shows that he is in judicial custody for more than 14 years, 6 months. Council Gandhi, he kaha ko engage kara gala? Mr. Mahanti, Pulakes Mahanti. Thile na kona avuru. Intimate, huh?
And ask him to move an application for me.
I would copy the 14 ବର୍ଷ ହେଇଗଲାଣି ହେଲା ଏଟା ସବୁ next week ଆସିବ ହେଲା ତା ଦେହରେ ଆଉ ଲେଖିବେନି କାରଣ custody certificate is already there ହେଲା next week ରେ ଆସିବ for the bail application file କରିବେ next
Item 27.
Rai Charan Patnaik. अच्छा एक्सपायर कर जाइए अच्छा এটা एक्सपायर कर जाइए तो अपडेट कर दियो है ना ये जो ऑर्डर अच्छी आगुरी से देखी लग गए
in the absence of any application
डिस्पोज ये जो 394 के अच्छी फॉर्मेट तो देखी लग यस नेक्स्ट
Item 28.
रश्मि रंजन मिश्रा आगुरी एंगेज नॉन अपियर्स कर दियंतु नॉन अपियर्स करियन तांको सीरियली करियन आउट एंगेज कर दियंतु हला अब कस्टडी पीरियड टा देखौछि भारत ट्रायल कोर्ट को 2/12/2010 14 years पाखापाखि ହେଇଯିବ कस्टडी also since 2000 है ना एंगेज कर दियंतु तो ये कस्टडी सर्टिफिकेट भी नहीं आसवे कहलेंगे नेक्स्ट वीक कर देबे बाकी और तो ये जो लिस्ट जो देखिए तब पर जहाँ तो एंगेज कर देंगे यस नेक्स्ट
Item 29.
Yes. So, Mr. Pani.
Yes, madam.
Have you received the paper book?
No, madam.
The paper book be handed over like that. And he is in custody since
15/11, I think.
24/2011. File the bail application.
Yes.
All right. Within 2 days you file, it will be listed next week. Huh? You obtain that custody certificate. Huh?
No, immediately after vacation, my lord.
No. We are listing all these matters for bail. We are not asking you to argue the matter on merit. These persons are in custody. You see, 2011 means they have already remained in custody for more than 13 years. Hello?
He committed 7 murders.
A case rate?
Yes, ma'am.
I don't know.
Entire family.
Yes.
Wife, 2 sons, 4 daughters.
Acha, era chotu babu. Okay. After vacation. Good. Next.
Yes, ma'am.
After
Item 30.
vacation.
After vacation.
Item 30.
Yes, Mr. Paul. Yes, Paul Nahanti, engage कर दियंतु council पे दे है ना बाकी लिखी देवे trial court record indicate that he is in custody since केवेरो 7/9/2012 है ना custody certificate obtain करिए और जो engage करिए next
Item 31.
Mr. Ashok Kumar Mishra. यही ना आती ये सब से तो engage change the council and now he is in custody since 9/8/2013 है ना custody certificate produce करिए next
Item 32.
Jatindra Mohan Rao. Change the council and custody since like example 17/6/2013. Produce the custody certificate la सब case रे एटा सब next week आसीबो हां council change हेगी ना reflect हबो तो paper book तम hand over करा जीवो ସେମାନେ file करिवे bail petition. You have to just to produce the custody certificate. Hello, next.
Item 26.
We have asked him, you have to file a bail application.
Yes.
He's in custody for more than 13 or 14 years. Hello?
File within 2 days.
Yeah. 33.
Item 33.
33 lordship, custody since 10/7/2010 lords. I have received the copy of the paper book lords. I'll file the IA for bail.
Now file. You submit that you will file the interim application for bail next week for them. And in the meantime, you obtain the custody certificate.
Yes.
Next.
Item 34.
अच्छा तो আমি অমিতাভ ত্রিপাঠীকে এনগেজ করছিল তো কোড করেছে ଅଛି ଯେ ଅନ୍ୟମାନଙ୍କ ସହିତ ରହିଗଲାରୁ ମିସ୍ କରୁଥିଲି अच्छा since lagi jantu as per the order dated 14/5/2025 this court has engaged Mr. Amitabh Tripathi as the counsel for the appellant. The name of Haripada Mahanti, Messrs. Jyotsna Rani Ratho and A.K. Sahoo shall not be reflected in the cause list. बाकी अपन टे कही देबे अमिताभ त्रिपाठी है ना से बेल एप्लीकेशन फाइल करिए यस नेक्स्ट
Item 35.
In item number 34, there is a prisoner petition.
34
There is a prisoner petition of 2024
34
to engage Mishra and
34
34.
34 we have engaged him now the that petition was taken into account
Yes, sir.
and we all passed the order है ना
Mr. Amitabh Tripathi.
next now 35 with report regarding custody period of the appellant may kindly be seen या नाटा होची कोन Paul James अच्छा এটা 11 years এটা কেবলে কার কি জানি 11 years রয়েছে with the council is not appearing you are there
Yes, ma'am.
your name is Shraddhanjali Sahu
Yes.
so how many years of practice you have
Well, it's 7 years.
7 years you cannot be conduct this 302 cases
You are associated with someone. You are independent.
the life imprisonment is 10 years practice necessary in view of the Supreme Court guideline and decisions also.
Mr. Mahapatra, you appear and she will assist.
She will assist you, huh?
No language. She will appear because 10-year practice is required. So, Mr. Mahapatra will appear.
Mahapatra is appointed as one also. Shraddhanjali Sahu is assist Mr. Mahapatra. Have you received the copy of the paper book?
Yes, ma'am.
Paper book copy has been
Share with Mr. Mahapatra.
and share it and you file an application for bail also.
Right.
Right. Because the trial court record indicates is the trial court record. In custody since 29/12/2010. So, କିଛି ଦିନ WhatsApp ପରେ 15 ବର୍ଷ ହେଇଯିବ
Immediately.
ଫାଇଲ କରନ୍ତୁ 2 ଦିନ ଭିତରେ ଫାଇଲ କରନ୍ତୁ ନେକ୍ସଟ ୱିକ୍ ଆସିବ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ନେଇ ଆସିବେ
Yes.
ବାକି ଗୁଡାକ ଲଞ୍ଚ ପରେ ନବ
Yeah.
Item number 36. Criminal appeal.
Bail.
With the direction of the matter, filed that I for bail.
Have you filed?
Yes, he already said the custody for 18 years.
18 years.
देखिए तो final form अच्छा 8/10/2007. Is he in custody or he has been
Custody.
He's in custody.
Custody, the report has come that he is the
Entirely.
Achha. Oh, he's in custody now. This
He is in custody.
Look at him. IN number so and so. This is an application for bail. Considering the submission made by the land council for the petition, that the petition is in judicial custody since 8/10/2007, and even though the paperwork has been prepared, there is no chance of hearing of the appeal in the near future. And considering the submission made by the land council for the state, we are inclined to review the petition on bail, stay relation. Yes.
At the young man, she is mentally retarded person. Nobody is there to take care of her.
That is, he has to.
What can be done?
Treatment at least to better.
He was there in custody. We are just granting bail.
For intimation of the order.
Fine. That order will be intimated. Yes.
Item number 37.
Previous official is in custody since 19th of December 2009, 15 years, 8 months. The lordship has also observed this on the last one. Call for criminal antecedents report.
I remember next week we will send the letter, but we have not received the custody certificate. And she also.
Next week. Next week.
Next week.
Ask you to obtain as per instruction dated from as per order dated from.
Item number 38.
Satyanarayan Jana engaged.
This is
After disengagement, yesterday I filed a case in this case. Therefore, yesterday my friend first.
No, it's all right.
He'll argue the case. I'll hand over this.
Where is Mr. Jenna?
Jenna is not there.
You have already filed an application for bail.
Yes. Yesterday I filed. I don't know whether I've been disengaged or not. Previously I was there.
What is the custody period?
11 years.
11 years?
11 years, 4 months. Paragraph 3 I am mentioning.
Where from you got that data?
Data from the lower court, he has taken the custody and sent to there.
No, this final form indicate that he is in judicial custody since 25/2011. So it must be more. Why you say that it is?
That's rape the minor girl and kidnap, rape and then murder.
Rape, it's
We just want Satyanarayan Jena. You
Karunakar file.
Council को engage करा इतना.
He is not telling Mr. Karunakar is there.
He was disengaged. Now he has come back.
No. Since I filed the miscase, I'll hand over the file to him.
No, it's all right. But
he is not coming.
He is not coming. He might not be knowing if you are engaged. He just recently.
Day before yesterday.
Day before
Mr.
yesterday.
Tripathi asked me the time that day.
The mobile number थियो ये जो ये हम communicate कर दो है ना बेटा आजकल आप ये करना कि मतलब हाई कोर्ट के जो हमारा सेक्रेटरी को कह दो लीगल एडर एकदम communicate कर दो है ना
let him get period of custody.
The as per order dated 15/9/2025, though Mr. Satyanarayan Jena has been engaged as amicus curiae and his name has been reflected in the cross list, is not present strong. Since the from the list, approved list, the Land Council has been engaged as amicus curiae. The Secretary of High Court Legal Services Authority shall intimate Mr. Jena about listing of the matter. No, about the listing of the matter, which happening. The matter posted to next week or that will be on 24th of September 2025. Next.
Item number 39.
Manual, the appellant is in custody since 13th March 2012. 13th March 2012.
High Court order should be. What is your good name, counsel?
Well, Siva Shankar Chen.
Four 498-302.
Your judgment.
Informant's sister, Smita Paramani, is the deceased in this case.
Susmita is the deceased.
There is no direct evidence, but
circumstantial evidence.
Basing on the circumstantial evidence, he has been found guilty.
In 313, he has admitted that most Susmita married.
The disclosure statement leading to discovery achieved. No fee. But he statement of co-accusation, statement of accused Japan as a media found origin.
Number 3.
So, heard the Land Council for the petition, Land Council for the state. The Land Council for the petitioner submits that petitioner is in judicial custody since 14/3/2012. He was not released on bail during trial, and as such, he has remained in custody for final control for more than 13 years. further submits that even though the paperwork is ready, but since there is no chance of early hearing, the bail application may be favorably considered. The Land Council for the state opposed the prayer for bail and submits that the charge against the petitioner to have committed the murder of the his wife, and the case is based on circumstantial evidence. And in the 313th TRPC statement also, the petitioner admitted his guilt. Considering the submission made by the Land Council for the respective parties, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, bail allowed. Yes, next.
Item number 40.
My lord, I am busy, my lord.
Yeah. 9/5/2011.
My lord. 8/5/2011, my lord.
9/5 were produced in
No, 9/5, my lord, my lord.
for court, and then you were sent to custody. What is the case against you? That is 302-382. Achha. Single person murder.
My lord.
Deceased Rajkishore was residing at village in Pudapara doing one. So this is
On the procedural circumstances, which last seen, my lord. Widow 30, my lord, page 132.
Last scene is the main evidence.
My lord.
Or the Land Council for the Petition, Land Council for the state. Mr. Das, Land Council for the petitioner submission that the petitioner is in judicial custody since 9/5/2011, and thus he has undergone more than 14 years of sentence. And though the paperwork has been prepared, but there is no chance of early hearing, and it's a case based on circumstantial evidence, and except the last scene of the deceased in the company of the appellant petitioner, there is no other clinching material available on record. Therefore, the bail application may be favorably considered. Land Council for this oppose the prayer for bail. Considering the submission, period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail. Yes, next.
No life, my lord.
Item number 41. Last time, also complete the reports, the medical reports. Medical report of the health condition of the accused. Hospital certificates.
Psychiatric patient.
Mentally sound as mentally physically sound.
କଣ ତା ସ୍ୱାସ୍ଥ୍ୟ ଅବସ୍ଥା କେମିତି ଅଛି? ଭଲ ଅଛି? Found nothing out of the report with your report line. Perhaps not.
By regular treatment now she
is physically or now normal. ଆଉ ଆପଣଙ୍କର ରିପୋର୍ଟ ଅନୁଯାୟୀ ହେଉଛି କେତେ ବର୍ଷ? 12 ବର୍ଷ?
ଆଜ୍ଞା 12 ବର୍ଷ 3 ମାସ 4 ଦିନ।
13 years ago. Custom.
35 2013.
Including revision, revision,
No criminal antecedent.
revision is not.
Revision or JCB. It's plain and simple like of the on the trial custody is the conviction 2 years afterwards, so capture 11 year old 12 वर्ष remission Mishra or the land counsel for the petition or land counsel for the state. In pursuance of the order dated 1/9/2025, the land counsel for the state has produced the custody certificate which shows as a from superintendent district jail for development panel shows that the petitioner is in custody, judicial custody for more than 12 years. And there is no other criminal antecedent against him. And the petitioner also physically normal. The reports are taken on record. Considering the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail, sterilization of fine. Yes.
3 months. 3 months.
No, bail.
Item 42.
এটা অরুণ কুমার বুধিয়া ও বুঢা কোন বিশ্ব 2017 এটা
Got shot injury. Death will
7 ବର୍ଷ ଖଣ୍ଡେ ହେଇଥିବ ଛୁଟି କରିଲେ ଏଟା ଅରୁଣ କୁମାର ବୁଧିଆ ହବ ନା ଏଟା ବୁଢା କରିଦେଇଛି ନା କୋଉଠୁ ଜେଲ କ୍ରିମିନାଲ କିଏ ତମେ ଏନଗେଜ କରା କିଏ କୋଉଠୁ ଆସିଲା
এটা ଅଛି
21 ହଁ ବୁଢା ଲୋକ ଏଇଟା ବୁଧିଆ ଆସିବ the name of the land council be correctly reflected as Arun Kumar Budia in the first distance vote. Stop. None appears for the appellant put up this matter after ensuing puja holiday. In the meantime, land council for the states shall produce the custody certificate, criminal antecedent if any against the petitioner as well as his jail conduct.
Item 43.
May I please reverse?
P02 case?
Yes, madam. Petitioner arrested on 24/5/18, never has been released on bail.
Arrested on
24/5/2018.
Eyewitnesses are there.
Yes.
2 to
2
4.
and 4.
But in the CD, they have been sected to chance witnesses, madam.
And who is the doctor?
Doctor is
17.
17. Had open up offense is X, madam.
Custody date kya hai?
24/5/2018. Stamped up with the family.
Let us see what the eyewitness is substituting. Eyewitness on 2W2.
2, 4,
2, 3 and
2, 3, 4.
wet triangle on occurrence took place about myself when I was sitting on the land. The Sahoo Hon'Ble is there in the motorcycle. Accused from sitting. Being armed with a tangia. The accused gave 3 blows. With one side of tangia to Sahoo Hon'Ble died in the spot. That is the evidence of all the.
Yes, same. Paddy Pile. But they have not lost the FR9.
17 is the doctor.
Yes. That X was recovered by the SO team.
Have you obtained the about instruction about the criminal antecedent?
No.
Get to listen.
No antecedent minor. It is in
The Land Council for the state took some time to obtain the instruction regarding criminal antecedent if any, then the petition, custody certificate and jail conduct after vacation. Next.
Item 44 minor. I was directed to take instruction from the family members whether they want to take this appellant or not. I talked to the in charge of the Kamakhanagar sub-jail. Superintendent didn't take up my call minor. Because it is factory, he is the organizer.
Producer Khuri. Pancho also. Chopped off the head with a file after vacation. Next.
Item 45.
45, 46, I am not going through the matter. I prefer next week. Next week.
Next week, yeah?
Yes.
Item 47.
46 malad, there are eyewitness malad. After vacation.
47. In the health condition of the appellant.
Unsound mind will it for you. And
this report
was not good. Like how you state submit that in the evidence of there is nothing at the relevant time to obtain information.
Even medication আছে ঠিক আছে
আসিলা রিপোর্ট আইলা
yes
Accused was maintaining well during regular mediation. As per the order dated 25/8/2025, the Land Council for the state has produced a report from the Superintendent Sub-Jail Rairangpur dated 1/29.
29/1/2025 ର ଡକ୍ଟର ଦେଇଛନ୍ତି next page
ପୁରୁଣା ଇଅନ ଯେ ଆପଣ ଆଣିଛନ୍ତି order data criteria. And the Land Council for the state wants to produce. It shows that the appellant is maintaining well under regular medication. He is now lost in Procedural guidance. The report taken on the track. How many years you are in custody?
Custody leadership is the date of arrest is 15/8/2021.
6821 ଲେଖା ହେଇଛି।
Yes.
Okay. ये 4 वर्ष जमा ହେଇଛି ଆଉ। ଏଟା ଛୁଟି କର। Next.
Item 48.
Administered to address your lordship through VC Miller. Am I audible, Milord?
Yes, yes.
Last occasion, your lordship sought for report regarding my conduct inside the jail and outside for 1 month bail, which I was released by your lordship. That report was your lordship awaiting. Last occasion, a wrong report.
No, he has brought it.
Milord. In custody since 6/2/2019.
What you have done?
It is death of the father, and only thing that went against me, Milord, dying declaration.
Exhibit 1 is the dying declaration.
Before?
Before doctor.
Doctor.
Exhibit 1 दबार करो कौन को? ये घटना केतल घटिला प्राय संध्या 6:30 रे मोर नाम कौन सुआंश ये घटना केतल गला मोर पुओ संध्या बेले मद पी अछि मते पैसा मागला मु पैसा देबा परे मध्य निशासस्त अवस्था में सहित बड़ी झगड़ा करी मुको सुआंश साक्षी देले किए?
Milord, in fact, no independent corroboration.
नाम एटा पण आपण घरे फेइथिबो ना बापा को आपण ई करछिन आ
हाँ घरे ହେଇଛି परा सर
घरे आउ कि अन्य मेंबर के नथिले?
हाँ थिले सिस्टर आसी पहुंचला
PW4 he deposed stated before the police that present petitioner he killed his father, and he PW4 also stated before PW10, 11 and 12 that my brother killed my father, but during the trial sister he turned hostile.
ये तो जी 6 वर्ष 5 मास अपन लिखछन मासे जाइथिला ना केते बा
मासे जाइछ
केबे ऑर्डर डेटेड केबे एक प्रभार के 12
आज्ञा he surrendered on 27 no milord 27/1/24 रे जाइथिला
17/1/25
हां 17/1/25 रे Land Council for the state has produced the written instruction received from IAC Town Police Station Khyamjur, which shows that during the interim wait period, nothing adverse was reported against the petitioner. Custody certificate was also produced that it shows that the petitioner is in judicial custody for 6 years, 5 months. The reports are taken on record. Since the petitioner, since the petitioner has not institutionalized the liberty while on interim bail as per order dated 17/1/2025.
Up to 2024.
And there is no likelihood of the offense being taken up in the future for hearing is granted interim bail for 2 months. Yes, next.
Item 49.
May the appellant is a lady. She is languishing in jail custody from 28/4/2021. And the appellant having a male child. who is residing with him in the jail custody.
Saraswati Behra.
Again, there is another accused person also in this case. He has filed appeal. That is filed with the before minor. What is the position of that appellant? I don't know.
He's not on bail. He's not on bail.
26 record hour.
In that case, based on the
He has been released on bail.
again,
Sinu has been released on bail.
Bail.
Mr.
Bail is
By order dated 29/1/23. Sinu alias Govardhan Mirza.
and in this case, yes, based on circumstances.
Just a minute. Arana. This is Gautam Behra.
Behra, so husband of the Saraswati Behra, the present appellant.
the present appellant along with the co-accused Govardhan Mirza, they develop illicit relationship and kill the.
But it's a case based on circumstances.
Yes,
The
madam.
evidence, there are two parts. One is leading to discovery under section 27 of the Indian
Govinda has been granted bail.
Say leading to discovery, so far leading to discovery of a weapon, that is rope, that is leading mark, that is recovered in the
The
instant
occurrence
of
took place inside the house of the
Yes,
present appellant.
এবং so far last scene theory is concerned, nobody has proof. And the informer, the brother of the deceased, he also resigned from the.
Question of last is not that. The husband and wife were there inside the house. The dead body of the husband found from the house.
Yes.
The present appellant was staying with the husband.
So now the fact that the
Yes.
co-accused
He has
been granted bail and this is a lady who was staying with a small child.
My
So
lord, that
hard
What's the
to learn.
period of custody?
My lord, that is 4 years, 4 months and some months. 15, 17 days, as it should.
Hard to learn counsel for the petition and counsel for the state. And counsel for the petitioner submit that the petitioner is the wife
Of the deceased.
of the deceased, who is in judicial custody for more than 4 years. And she is staying in the jail with her breastfeeding child.
co-accused was on bail during trial. But the co-accused was on bail during.
आपको कहीं कोरिडोर पर आपको
The petitioner faced trial along with one judgment. Along with one Innu alias Govardhan Mirza for offense punishable under section 302/34 of the Indian Penal Code. And both of them were also found guilty under the offense charge. And in the meantime, the co-accused Innu alias Govardhan Mirza was preferred a separate appeal, that is CRL number 26 of 2023. Has been directed to be released on bail by this court by the order dated 1/2023, and therefore the bail application may be favorably considered. And counsel for the state of this day of Nigeria, considering the submission, the absence of any direct evidence, nature of circumstantial evidence available on record, period of detention and judicial custody, release of the co-accused on bail, and since the petitioner is a lady, we are inclined to release the petitioner on bail, sterilization of fine. Yes.
Item 50.
The appeal is conducted under section 305 and is in the custody since 19/3/2017.
Speak little louder, madam.
The appeal is in custody since 19/3/2019.
19/3/2019. No. you are-
2017.
17. তাহলে 17/8 বর্ষ 6 মাস। আচ্ছা, মহেন্দ্র কুমার।
Yes, between 2 and 4 are eyewitness to that crime. While the deceased was taking his meal, the
Deceased
present
was taking
his meal.
9.
The present petitioner enter inside house and stab. Number of injury. PW 11 is the doctor. I found the accused overpowered the deceased and the deceased fell on the ground and the accused was stabbing him. with a-
injury किया है PW के
11.
Plus 96.
एवढा घोडा आहे stab into
8 number of stab wounds.
last 54 upgradation. Next.
Item 51.
My love. My love, prayers for bail. File number 251.
Wait. Prisoner's petition has been received, which is at large B, wherein request has been made for engagement with Meenapan Tripathi and Bangini Tripathi as his counsel. Ms. Meenapan Tripathi and her associate has filed power for the appellant, which is accepted. The name of Mr. Satyanarayan Mishra solemnly reflected in the cause list henceforth. After the IN numbers so on, so these are application for bail. So since anyone in custody?
12 years, 6 months. Because 25/3/2013.
25/3/2013.
13.
6/3/2013. There are 12 also. Which one was on the
What are the evidence against you?
Madam?
What is the evidence against you?
Come to paragraph number 2 of the judgment.
Madam. Madam, the case of the prosecution in brief is that on date 24/3/2013 at about 9 p.m. the informant Nobin Janda and he lodged the report alleging that his sister Lakshmi Pradhan, the deceased, and her husband, the accused, were working in the labors of the Karmakshetriya Pari by residents in the village in the Gopal. On dated 23/3/2013, his sister and obtained 150 kg rice pocket from the Karmakshetriya Pari for their composition at the daily following. With date 24/3/2013 morning, the accused took away and disposed of such a rice pocket for which there is quarrel between the accused and the deceased. On the same date of the about 5:30 p.m. while he was returning home and attending call of nature, he found the tussle between the accused and deceased in front of the house of his mother, and that immediately the accused who was holding the priority that chisel on the neck of the deceased, for which the deceased is the Alaram Rajamago Marigali. He and Pramod brought in the spot. Pramod sustained out the chisel from the accused and of the land, the deceased in the speaking condition.
Is there any eyewitness?
Schedule 1.
Schedule 1.
Doctor.
PWA is doctor.
Incised wound, abrasion. Eta incised wound, external. Neck had a cut injury on the base, so weapon was
One is
examined and
immediate.
doctor find that all injuries are antemortem in nature. One and two can be caused by sharp-cutting weapon, and death was due to shock and hemorrhage. Okay. So one is the eyewitness. He
He is
has
the
stated-
informant and he has this stated that I can play that.
It's done hostile also.
That.
So one has not supported the prosecution case. Yes, sir. He has nothing, he has stated nothing there. 2 to 3 years back, one evening when I returned from my sponsor, I could find a gathering near their house of the accused, and which was quite nearer to my house. Then I proceeded there, found my sister was lying dead on the veranda, and I noticed some injury. That's all.
That's it.
So how can he be an eyewitness? So he has not supported the
Immediate.
case. Any other evidence?
That.
Or the learned counsel for the petition, learned counsel for the state. Learned counsel for the petitioner submit that the petitioner is in judicial custody since publicly claiming Gejas clear, and as such he has remained in custody.
25 days that way.
25 दिन आपण arrest हेले 26 रे
26
हेले 26 दिन 2013, and as such he has remained in custody for more than 12 years and 6 months. Stop. She further submitted that the PW1 was examined as an eyewitness to the occurrence, but he has not supported the prosecution case for which he was declared hostile. Further submits that there is no other clinical material except the evidence of the doctor, bracket the PWA, who conducted post-mortem examination and noticed 2 incised wounds on the person of the deceased, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and praised the evidence of PW1 and PW8. Considering the submission, nature of evidence adduced during trial, since the eyewitnesses has not supported the prosecution case, keeping in view the period of detention in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail. The name of Mr. Satyanarayana and Mrs. shall not be reflected for the gender. Yes, next.
Item 52.
Minor.
Yes, please.
Minor is a costed certificate as well.
Custody since 2015.
11 years.
What is the your father has been committed dinner at that time accused Govinda out of gross came at 12 midnight with a tangia, dealt successive blows on the forehead, neck and head. Eyewitness achandi? Land counsel for the state submits that he has not received the copy of the paperwork. Let the office supply the paperwork copy to the land counsel for the state. Put of this matter after Puja holidays. Yes. Next.
Item 53.
I favor that Kyle is not with me next week. 53.
Next week.
No, next week.
And the paperwork you have received. Have you received paperwork?
That Kyle is not with me. I'll check it.
They check for them. The land counsel for the appellant is present. Land counsel for the state submits that the file is not available with him right now. and the matter may be taken up next week, put up this matter next week. Yes.
Item 54.
Evidence copy is not supplied to me, my lord. Kindly be bail petition can be taken up.
Pen drive ଅଛି ଆପଣଙ୍କର?
Again.
Pen drive ନେଇଯାଅ ହଁ ସସ୍ମିତା ମତ and councillor ଆପଣ ନେବେ ନାଇଁ paper book ହେଇନି but you can because it's a jail criminal appeal you can take the position copies. Sasmita Nanda, source of the Land Council for the state submits that they are not having the position copies of the witnesses examined in the trial court, and since the soft copy of the trial court record is available in their the copies of the deposition may be supplied to them in their pen drive. Let the registry supply the deposition copies to the Land Council for the respective parties in their pen drive. Put up this matter after vacation. Yes, next.
Another petition is stay for realization of fine.
Stay realization of fine allowed. Stay fine allowed. Delta you after puja holiday.
Item 55.
May I please nursing matter? 302 case matter, which corporate since 2017 matter. 15/1/2017. 15/1/2017. I witnessed them at 34578.
The double murder case. The double murder case, I witnessed is there.
But IO has not been examined.
To be for the next. Now you obtain that CA criminal antecedent jail conduct. How custody certificate.
So vacation.
Yes. Next.
Item 56.
May I please the lordship? My lord, here my lord, appellants are in custody since my lord 9/2/2010. And they are planning to produce the death certificate of appellant number 2.5. That in the meantime, one of the appellant, namely Bhimo.
No, how many appellants are there in this criminal appeal? There are 3,
my lord. So, Munna, Ali Santarjami Patra, and
who is dead now?
Bhima Singh, appellant number 2 has already been died.
Others are alive.
Others are alive.
Just a minute.
And your lordship was pleased to
just. We granted bail also to the appellant number
1 and 3.
1 and 3, right?
Interim bail.
3 months.
And they have surrendered in right time. And they never violated
No,
any.
that is one thing, but about so far as 2 is concerned, you are asked to produce the death certificate or something like that.
Look, I am unable to collect because they are the nobody is there, my lord.
How you got the information? Your party said that.
Yes, my lord.
Submission was made. You have made the submission.
Yes, my lord. Yes, my lord. I have made submission.
That and the registry was also directed to obtain a report from the superintendent Sahoo Hon'Ble. Neither the Land Council for the appellant has produced the death certificate of appellant number 2, nor the registry has so and so. Let this so and so produce the Land Council for the state obtain report from the jail superintendent to appellant number 2, Himma Singh. She died really confused. What is your instruction?
Do you have instruction?
Not received.
Circle jail, Baripura.
There is
get that instruction. That appellant number 2.
And their conduct also.
Abate korijibo. Baki hochi emane jo jaithile bail le tankar conduct kon hala.
That instruction was also sought for on the previous date.
Sending the letter but not received the law.
No, the order was passed on July 2025. We are in September. 2 months irani apono.
It will exist.
Chithi ଯାଇଛି.
ଯାଇଥିବ କଣ ତମ ଦଉନାହାନ୍ତି? The You pursue again, no? Next week or so. Run counsel for the state has neither obtained instruction regarding the death of the appellant number 2, Bhima Singh, as per the order dated 23/7/2025, nor he has obtained the instruction regarding the conduct of the appellant number
1 and 3.
1 and 3. We are directed to be released on inquiry as per order dated 25/9/2023. Hello. We take some more time to obtain the same, put up this matter next week. Yes, no.
Well, next week, man.
Yes.
Fix up a date, man. Right there.
Good hour, you know.
Thanks. Bless your lords.
Item 57.
Please, Your Lordship, on behalf of Mr. Pandam, Your Lordship, may kindly have a glance to order dated 3/9/2025.
3/9/25.
Lordship had called for the conduct report of the appellant while he was
released on interim bail thrice.
My lords.
So surrendered at right time. Seek some time to obtain insurance conduct. Actually,
The conduct has not been shown.
आपण लेखुचन ना चुपचाप बजे होते ना तुझी कोण ऑर्डर तो संध्या बेले अपलोड हैला कोर्ट रे सामने डका होची आपण सुविधा कोठी हो next week next week Prabhu Davarjanani Grand Council for the state submit that you may be given some more time to obtain the instruction regarding the conduct of the appellant during interim bail period as per the order dated so on so 3/9/20 put up this matter next week with CRLA number 593 of 2015. Yes.
Make a note of it and get the instruction.
Unnecessarily adjourn hochi na. Yes.
Item 58.
Yes. Responsibility custody since 29/4/2000 reliance. More than
Really जाई ना फिर जमा. तो अपन bail reject ହେଇଛି 3/2/9/23 रे. अच्छा ता पूर्व मध्य रिजेक्ट ହେଇଥିଲା 4/12/2023 ବର୍ତ୍ତମାନ କେତେ ବର୍ଷ ହେଇଗଲାଣି
14 ବର୍ଷ ହେଇଗଲାଣି ମାସ ମଝିରେ ଯାଇଥିଲା
କେବେ ଯାଇଥିଲା ମାସ
କୋରୋନା ଟାଇମରେ
ଓ ସେତେବେଳେ ମାନେ as per the order of this court
yes madam
କେବେ ଗଲା
order dated 3/3/2021 3/3/2021
3/3/2021 କହୁଛନ୍ତି ठीक तो कहीं ये कहीं कस्टडी सर्टिफिकेट कहीं जानी कॉपी अच्छी था इंट्रीम एप्लीकेशन ना 1731/2025
No, the nice to
item number 58 CRLA 104 of 2016 IN number 1731 of 25 this is an application for bail have you got a copy of the interim out a copy the IN number so and so for bail let a copy of the interim application be served on the land council for the state stop. The land council for the petition submitted that the petitioner is in judicial custody for more than 14 years. Land council for the state seeks some time to produce the custody certificate and also the conduct of the petitioner inside jail. Of this matter and criminal antecedent also. Of this matter after vacation. Next.
Item 59.
পুনः এটা সেম কি রক্ত গেলে সে লেখক তুমি সে অটোমেটিক পড়ে গেছে শুক্রবার দিন yes
Item 60.
yes Mr. Sahu
Appellant is with custody since 13/10/2012 and he was
comprehensive affidavit में थिला यार
I was intimated to the father of the
antecedents are found
father of the appellant.
data antecedents are last time ସେମାନେ ଗୋଟେ
The
complaint
antecedent ଥିଲା I was intimated to the brother of the appellant to come forward but he did not.
कौन है ला
86
अन्नंती आणि केबेकार केस की प्रकार केस होला
302 your lordship
ଓ ଆର ଗୋଟେ 302 ଅନ୍ୟ ଯୋଉ ଦିଟା କେସ୍
ସେଟା ହଉଛି
307
294 325
27 after 394
and the on the earlier occasion it was directed to take instruction the conduct of the petitioner during the course of interim
bail সেটার কোন আনলে
সেটা
এটা ଯୋଉଟା এই ଯୋଉ ଦିଟା କେସ୍ କଣ ସେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ରେ ଗଲା ବେଳେ
ନାଇଁ ନାଇଁ
prior to that
ଇଣ୍ଟରିମ୍ ବେଲ୍ ଆପଣ କେବେ ଯାଇଥିଲେ
12/5/2023 in I number 1088/2020
appellant କୁ contact କରନ୍ତୁ ନହେଲେ ସେ ଯଦି କହିପାରୁନାହାନ୍ତି ତାର କିଏ ରେସ୍ପଣ୍ଡ କରୁନାହାନ୍ତି ସେ ଯୋଉ ଦିଟା କେସ୍ ରେ ଇଏ ଜାଣିଥିବ ନା
he was on bail
କୋଉଠି
by the learned court below
no whether those cases are pending or
cases are pending
12 ମସିହାର କେସ୍ କହୁଛନ୍ତି ପେଣ୍ଡିଂ ଅଛି
your lordship may have this
Where the status?
status ଟା ଆମେ କୋଉଠି ନା ପାଇଁ
that was the status
those cases are of the year 2012 କୋଉ କୋର୍ଟର
ଏଇଟା ହଉଛି
କାଙ୍ଗପୁର
ଭଞ୍ଜନଗର
ଏଇଟା ଗୋଟେ ହଉଛି 340 of 2012
ଆମର କାନପୁର PS case number 88
394 ସେଟା
and counsel for the state seeks some more time to produce the instruction relating to the conduct of the petitioner while on interim bail as per the order dated केबे ଯାଇଥିଲେ
order dated 12/5/2023 in I number 1088 of 23
for the order dated 12/5/23
and that was extended
ନା ସେ ଠିକ ଅଛି ଏଇ ତ ଯାଇଥିଲେ ଏକାଥରେ ଏକ୍ସଟେନସନ ହେଲା ଏକାଠି ସରେଣ୍ଡର କଲେ ହବ
ଠିକ separate date unless
after that
Item 61.
सुप्रभात